Good morning. This is the New York City Board of Standards and Appeals Public Review Session for March 26th, 2018. We'll begin with the special order calendar. Decision item 6296BZ, 200 Madison Avenue, Manhattan.
Okay, we received an affidavit of fire alarm inspection from a fire alarm installer. We also have a rather strange affidavit, I might say, from applicant's counsel's office, stating in their affidavit that they have been informed there are no longer massage services performed at the facility. That's the strangest affidavit. Shouldn't the affidavit come from the owner of the facility saying there are no longer massages being performed? I'm surprised, actually, that the attorney would submit such a thing. Anyway, and in addition to which, the floor plans show a physical therapy room still. So I'm not sure who does physical therapy. They're called physical therapists rather than, or maybe they're called massage therapists. Nonetheless, they need licenses. That's what this special permit is actually supposed to be about. Anybody else on that?
So you want revision to the plan, or do you want something?
Well, so the affidavit should come from the owner. I don't understand why the owner can't sign an affidavit. And they should explain how the physical therapy room is being used without a physical therapist or a massage therapist who needs a license, right?
Go. Continued hearing items. Item number 2, 16998BC, 3141 Bailey Avenue, the Bronx.
Photos were submitted showing a new chain link fence with black slatting and a new metal picket fence along the perimeter, both of which are great improvements. The place looks downright spiffy. They planted the tiniest arbor vitae trees they could find at Home Depot's plant department along a narrow planting bed that doesn't have a curb. So I give those little trees about 4 hours because they're going to get run over by parking space number 9 and 10. But anyway.
They removed the planting last time. The last time they were before the board, they put up planting and removed it, from what I understand.
Right, yeah.
So I'm not sure, I'll second, I'm not sure how long those plants are going to live.
Right. So one of the things we talked about was putting this on a very short leash because it's been a very problematic site. So by putting it on a short leash, we'll be able to take a look at the viability of those teeny little trees. But I do think they need to add curbs. At the very least, those movable, those big concrete ones you drop down as opposed to something it's too late to build a curb, they've already dug the hole. We also have a fire department sign off on the site. Anybody else on it? Were you able to drive
No,
by it?
I haven't been able to go by again.
Okay. So I understand tomorrow the tenant is going to be attending this hearing?
Yeah, with his
Right.
daughter to interpret
Yeah.
for him. Yeah.
Right, okay.
Item number 3, 14307BZ, 6404 Strickland Avenue, Brooklyn.
I just want to make a note on this in terms of how this was organized. This submission was inserted in the initial application folder. So as far as I could tell, nothing was submitted until I started digging around in the initial application folder. So please make sure later submissions are in their own dated folder after the initial. The applicant submitted a list of DOB objections showing that the plans were reviewed for flood zone compliance and that this project is viewed as a substantial improvement. I thought that list of objections was really helpful. They went through every single section of Appendix G. They didn't do a zoning review of it, but they did do a code review, and I thought that was super helpful. One of my last comments on this project was that the corner bulkhead, which is located tight to the front corner of this corner lot, is visible behind the architectural features, which the applicant doesn't want to call the Tudor style, but architectural history names things. So it actually, that's the way it goes in architectural history. So, but instead of showing that the features that were created now hide the bulkhead has been actually vanished from the elevations. So to show that the bulkhead would disappear, they should just dash in the bulkhead behind the architectural feature to show that it's not going to appear. And as just a note, because there was a lot of protest about this being a iconic building that they're replicating because it's the building that's replicated around the world. And so another bit of architectural truth, when you replicate a building, you replicate a building. Therefore, staircases are in the same place. If there was no elevator, and so on. And when you can't replicate the building, you have to make adjustments to the design, and you make reference to the icon, but you're making adjustments to site conditions, and program requirements, and that's how it goes, right? It's called basic architecture. Anyway, anybody else?
Yeah, I saw a FEMA map, two FEMA maps actually submitted as part of the plans, the first page. Both of them says effective, so the 2013 says effective, and the 2007 says the same thing. In addition, the 2007...
7 is old, 2013 is the effective.
Yeah, but it was put like under the map itself, like it says effective, so I believe one of them should be effective, and the other one should be obsolete. The second thing is the 2007 one is not legible. I tried to like zoom in to see what is written there. I wasn't able to see anything on it.
Okay. So, but basically what's happened is the 2013 maps are the ones that everyone has to be using, even though they're not officially adopted yet.
Yes.
Right, okay, so, and this one, we were lucky to have a good set of DOB objections, so they really reviewed the code requirements.
Okay.
And they checked off each of those, so it looks like each of the concerns was resolved at the Department of Building.
My question is with regard to the community board's objection. Has there been any resolution to the parking issue or a traffic issue in that area?
In terms of the Strickland Avenue site?
Yes.
So this is just an extension of time to complete construction. So we don't open again the whole variance application. The reason why I'm looking at the bulkhead is they came for a revision of the plans to modify some of the layouts, and that had an effect on the design of the building.
Okay. And
that created the bulkheads and their sort of design change. So. But we often have this issue with houses of worship that they don't provide the required parking, and the board often grants waivers of the parking based on the concept that most of the congregants walk to the site during the peak times.
Thank you.
Okay.
Move on. New cases, item number 4, 43653BZ, 14150 Union Turnpike, Queens.
Okay. We have proof of service of initial application and notice of hearing to officials. Community board recommended approval with 1 opposed and 1 abstention. The community board provided what reads like a transcript of their hearing, so that I was quite impressed that they actually have a transcript, at which neighbors spoke about noise and lack of privacy between the existing gas station and their homes, and the fear that by reducing the buffer area as proposed, there would be reduced privacy and increased noise. There was also concern expressed about the status of the existing underground storage tanks. As there are no notice to neighbors requirements for these extensions of term, in this case, because the neighbors were so vocal at the community board, I'd like them to be invited to attend or submit written testimony for the next hearing, because I don't think they're aware that this goes to another agency. That I think they thought the community board was the last stop. The history of amendments to the pre-61 variance shows repeated addition of service pumps. I just wanted to understand, it seems like they went up, they went down. And I just want to clarify what the total is and kind of that history. It also shows that the building was enlarged after 1989, it's pre-61 variance. And this proposal is to further enlarge it. The applicant states that the scope of the enlargement is permitted under section 11-412 as not exceeding 50% of the floor area of the existing 1961 building. And when I did the math, it's exactly 50%. You couldn't have 1 square foot more. So I caution on those kinds of things because we know things never get built the way the drawings show. So they really should be under by, it's the fact. No, that's just the fact about surveys. That when you are saying you're going to build something, let's say that's 4 feet 4 3/4 inches, they don't build to 4 feet 4 3/4, they build to 4 feet 5. Now, so 4 feet 5 inches. So now your building exceeds the 50%.
Well, as a rule, don't we always round up if it's more than half of an inch, say? So if they say they're building to 4 3/4, they're going to say it's, I'm sorry, if they say they're building to 5 feet 4 3/4 inches, it's actually just 5 feet 5.
4 feet 5.
4 feet 5, sorry. That would go to the whole inch.
We can, but again, they're going so tight to the FAR allowance that to play it under a little bit so it allows for variations in construction. I'm just saying that they could easily go over the 50% in the field.
Could,
right?
But we can't presume that they will, right? It's a DOB enforcement issue, right?
Okay.
Plans say what the
Right.
plans say.
Plus,
yeah.
we've always allowed them to go up to the 50% because that is what's in the.
That's what it
in the
says.
ZR, you know?
Yeah, that's just very tight.
Noted
Totally
for the
tight.
record. Yeah.
I'm also concerned that the proposed attic area that's described as being for mechanical use, but looks like it will have structural headroom, will count as floor area. I'd like to know, is that part of the existing structure, or is this a proposed entire attic level? Like, I know the existing structure has a pitched roof, but it's not shown on any of the previous drawings as having structural headroom, and now clearly it does, otherwise you can't use it to get a mechanical installer in there, equipment in there, a guy to work in there. So I need more, and that would certainly be additional floor area. I note that the Youth Group 16 grant was for only a portion of the zoning lot, and the proposal now is to extend the use into the portion for which such use was not granted. And I don't know whether that's permitted under 11-412. So it's the same zoning lot, but the grant was only for the non-sort of vegetated portion. So there's like an ever wild area that they want to expand into. And I just don't know what the rules are. So maybe either Carlo knows or they need to speak to that.
I mean, the 1141 limits it to the lot area of the zoning lot that was in existence in 1961. As to the condition that's been historically imposed to not utilize that rear section, I'm not sure legally if that would exceed.
No, it's not a condition to not utilize. The grant wasn't for that portion of the zoning lot. So it's the same size zoning lot, but the grant was only for,
Yeah.
2/3 of the zoning lot. And so that, I don't think that 1141 contemplates this. I just don't know how the board has handled things like this in the past. So actually, I'd like to just pose to the applicant that they do some research about that subject and show that the board has allowed those kinds of expansions of a use onto a portion of the lot that wasn't included in the grant, right? I mean, as an extreme, you would say that part of the lot is supposed to remain residential, right? Instead, they just left it wild. Okay. So then the other question is, they need to show that the proposed convenience store complies with the technical policy notice 10 of 99 for accessory use, because it's getting to be quite large relative to the site. Their certificate of inspection and compliance, which is signed and sealed, and this is my peeve always, signed and sealed by a licensed engineer states that the site is in compliance with the terms of the BSA grant when the statement of facts and conditions compliance chart state that it's not with respect to signage. So I just ask out there, what's the point of having a licensed professional make such certifications if they neither go to the site or coordinate with the attorneys who are managing the applications? And this is really directed at the attorneys who are supposed to be managing the applications. The signage calculation sheet has to be redone to show how the proposed signage complies with C1 regulations. Signage has been for the last 70 years restricted to 112 square feet, and now the request is to increase to C1 levels. Photos show a lot of signage not depicted on the drawings, and the drawings show illuminated signage far in excess of the 50 square feet permitted under the C1 regulations. The proposed drawings show most signage removed and in compliance with C1, but that signage, all that excess signage on the site needs to be removed now. So the 1950s, whenever I read these 1950s resolutions, I get a little sort of nostalgic or something for those good old days that we didn't get to participate in. They seem to have been the BSA's heyday in imposing strong restrictions on the aesthetics of gas stations, which included the protection of adjoining property owners from these uses by using dense landscape buffers and walls, and in enforcing the conditions. The BSA even reviewed the construction documents before submission to the Department of Buildings, which is what's done by the Landmarks Commission today. Sadly, though, over the decades, people in New York City have become more immune, perhaps, to this sort of a neighbor, and or have just accepted fate, and those protections have been whittled down. In this case, there was a 35-foot buffer zone with landscaping between residential properties, high walls, and a strict limitation on signage. And now we fight for having, what is it, little tiny arbor vitae in a little planting bed. So I'd like to know whether the proposed number of parking spaces comply with the parking regs for the C1 district. They need to show materials on the elevations. And the prior approvals in 1989 showed landscaping between the blank rear wall of the building and the wall that separates the buffer area from the building. The proposed drawings show asphalt, which in that funny little area that's about 5 feet wide, which we now know from experience just ends up being a storage area for junk. So unless there's a good explanation for it, because it's a blank wall with no doors accessing it, that area should be landscaped as well. With respect to the underground storage tanks, there is a record of an open spill report and removal of an existing tank. I'd like to know if we have confirmation from DEC that the site has been properly attended to. That should be the approach on all of these gas stations, all the extensions. And those were my comments.
I had similar comments, and since we do not know what the condition of the buffer area is, they should provide documents, photographs, write-up, and what the condition of the wall and the fence beyond it that would be abutting the rear property line. And I had same comment on the signage, and they should also provide the lighting spread plan, because that has been a concern that has been raised by the community, so we should get a lighting spread. And the signage and others is all the same comment.
I had similar comments, but I also was concerned about the refuse bin that's going to be right against the residential neighbors on the south side. I understand that the pickup is at night. The neighbors, their basic concern and complaint was the noise level, and I think that would certainly add to that. So that, and along with what the need is for more signage, and as they have been in non-compliance, the last BSA decision, they were way outside of the signage requirements then, and now they're just requesting to remain outside of that.
Anybody else?
Ready? Item number 5, 39359BZ, 1945 Bartow Avenue, the Bronx.
Okay, we have proof of service of initial application and notice of hearing to officials. Community Board recommended approval with 29 in favor, 1 opposed, 5 abstentions, and 4 recusals. Something's very interesting about this site. Statement of facts has a mistake in the total area of the zoning lot, very big zoning lot. I didn't see a DEC underground storage tank status letter, which we need, and otherwise I didn't have any other issues. Anybody else?
I had some question, and that was again going back to providing a spread plan. Also, they need to provide documents confirming that the use has been in operation since 2012 to present. I don't think we have that.
Say that one more time. Confirmation that the use has been.
That the use has been in operation since 2012.
Okay.
It has been.
It has, okay, it wasn't clear to me.
No, they should provide the documentation, but just so you know, it has
Because
been.
Okay.
you drive by
I
it,
drive
you
this.
get
Yes,
there.
this is on my route.
It's Bardo Avenue.
So it's just for then documentation
Is there a
purposes, we
car
just need
always
that.
parked on that side?
With regards to compliance, the photos
Is it
that the
that-
applicant has submitted shows that there is vehicles are parked on the sidewalk. So they need to just give us some assurance how that is not going to happen. And I think the signage may be in excess than the permitted based on the photos provided. Specifically, there are some banners facing the Edson. There are some posters, and these are mounted on the enclosure for the garbage area. There's some, so there are some extraneous signage. So that needs to be checked and verified.
Anybody else?
I didn't see a firm map submitted.
In this case, because it's an extension of term, they're not proposing to do any work. If it was proposed new construction work where they're building foundations or something like that, then we'd need a firm map, but extensions of terms don't. Okay.
Item number 6, 13887BZ, 21836 Hillside Avenue, Queens.
Okay, we have proof of service of initial application to officials, but I actually didn't find proof of notice of hearing. So, whose is this one? Daryl? We need proof of notice of hearing. I didn't find that. I saw that there was a late submission on service of initial, but I didn't find anything about hearing notice.
I saw it.
I saw green cards, but the green cards are old, so they wouldn't have been hearing notice. Community Board recommended approval. This application is in part a legalization of interior modifications to the existing building to support the car rental facility. This one I really need Carlo to listen to because this is what
We actually did it.
I
saw it Friday.
No, I looked at the proof, and if you look at the dates of the cards, they're old, so they don't, you have to look at the dates to make sure that they're relative to service versus notice, right? You can't just say, here they are. You really have to look deeper, which is one reason why we really need to clarify what the rules are for service and notice, because people just send us cards and they're not attached to anything. And but anyway, so if we could just clarify that, and maybe the applicant, in fact, the applicant should bring tomorrow proof of notice, right? So this application is in part a legalization of interior modifications to the existing building to support the car rental facility. There's also excess signage that needs to be removed to comply with C2 regulations. And so this application has a very strange approval history that I would like to see if we can clear up. The 1987 resolution makes reference to, so this is a gas station, this was a...
Car rental facility.
No, sorry, it's a pre-61 variance for a gasoline service station with minor repairs. There was an amendment, so in 1987, the resolution makes reference to a special permit to reinstate the gasoline service station use without providing, and it doesn't make reference to this section, right? Subsequent resolutions refer to a variance. So it's like all over the place. And I'm hoping that maybe we can figure this out. So I'd like to know, was the 1987 application a special permit for automotive service stations under 7321? And could the board have permitted a change in use to car rental under that special permit? So is this an application to extend the term of a special permit? Because it's described in our materials as a variance.
They applied a 73-11 at that time for the automotive, for an automotive service?
So that's the point, is the resolution makes no reference to any section in the zoning resolution. It just says a special permit.
It could be, just to clarify, and we'll look into it obviously, but it wasn't uncommon that sometimes when a pre-1961 application was placed on the BZ calendar to reinstate it, that they would be referred to as a special permit because it's under the same authority under 7301. And that was something maybe in the last decade that we really moved away from. So sometimes just they have been referred to historically as a special permit, but it could be that it was a reinstatement because either the term had expired or the board's practice in the past was a change of use would require it to be.
No,
on
the term
BZ
had
calendar.
expired. The term had expired,
Yeah.
so,
We can
okay,
look
so
into it.
so we
We'll
need
look
to
into
dig
it, yeah.
in.
We'll look into it.
Right, so I'd say internally, but also the applicant has to look into this to clarify, so we need the case file. Okay, and then I just wanted to understand whether there are still incidental repairs and sales on the site, because it's described as a car rental facility, and it's enterprise rent-a-car, so I didn't know that they make sales, do they?
Well, the papers make reference to still repairing. It seems like it was cars that were going to be rented that are just maintained in terms of like oil changes and that kind of thing.
Right.
But they do need to clarify that and clarify whether or not it's actually open to members of the public.
The repairs.
Yeah.
Yeah, the repairs, because if it is, then they need to then show that they have parking spots for cars awaiting service and that kind of thing. And right now, they don't. They just have the parking spaces, and there's no specific use that they're attached to.
And the use group might be incorrect.
Right.
And then they also need a light spread diagram, and I didn't see proof that the USTs were removed from the site. So they don't show them in the plan as being dashed in, but it's probably because they're not noticing them. Anybody else on this?
This, again, I did go to the site, but I did not go to the site, I just want to make it clear. But I was looking at the photographs that has been submitted and the Google Street View. It seems the existing sign is higher than than permitted 15 feet. So I would like the applicant to clarify that. Just using spatial analysis, it seems it is higher than the permitted 15-foot height. The photos were not very clear with regards to the landscaping condition and the fence condition in the rear on the south lot line, so I would like the applicant to provide that. At least from the photos that has been provided, there is graffiti on the chain link fence in the rear along 218 Place. That needs to be cleaned up. And also it seems there are more cars parked than indicated in the plan. So they need to provide photos of the interior space where the vehicles are parked.
Ready?
Okay.
Ms. Winnie?
Do we have violations for this site? Any violations in that?
Do we have what?
Violations, does the site have any violations?
I
Because
don't
I didn't see
remember
any.
if usually we ask them to submit a violation search. I don't remember whether they did
They
that.
haven't addressed this in the statement of fact. I didn't see any
Okay.
discussion for the site violation. Even the description for the property, it's not in the statement of fact.
Yeah.
I,
No, I agree, it was a very difficult description to read. I had to read it a few times before I could figure out what was going on. But yeah,
and since we're permitting changes for the layout of the building, should we ask for a firm or because it's...
no, because these are interior modifications, right? Actually, yeah, these are interior modifications.
Okay.
It's really just that they made an office over here and they
Yep.
took out a wall
Yep,
over there.
understood.
So.
See email.
Okay.
Good. Item number 7, 6090 BZ, 525 Forest Avenue, Staten Island.
Okay, there is a February 12th letter in the file requesting adjournment, but I think that was of the February 13th hearing.
Right.
Yeah,
It's
this
very
is a
good.
postponed hearing.
Yeah, okay, so it's not indicated on our calendar as having
Yeah,
been
we just,
postponed. So that should have been indicated.
Yeah.
So we have proof of service of initial application and notice of hearing to officials. Community board recommended approval with 1 opposed and 1 abstention. We need on this one also a clean DEC report about the underground storage tanks. The photos show the site is unkempt behind the fenced-in area, which needs to be cleaned up, and the dumpster must be kept behind the fence. So I always am surprised when they submit photos of how terrible the place looks. Now, usually you get dressed up for photographs, you know? Photos are very unclear as to the state of the plantings, especially those in the planter tubs, so they need to give us cleaner photos. And they need to clarify whether the proposed signage complies with the C2 zoning district regulations. This is an interior lot, and I don't believe it does. They've had some little argument that if you had 2 frontages, you could have more, but they don't have 2 frontages.
There's only one street.
Right? And so we also need a light spread diagram and, I think I said that, a UST status letter. Anybody else?
No.
I think that the site needs to be cleaned up. It's pretty, I'm going to have to do a site visit because the photos were quite grainy. Not sure what I was looking at some places, but I'm not sure if repainting is necessary, but something needs to be done there.
Well, we sometimes say repaint, you know, it's been a while, right? So,
I'd also like to know what the opposing, why the person on the community board opposed,
right.
if there's a...
So this, you know, we see so many different kinds of community board recommendations, and sometimes they're so detailed, like that one that gave us a transcript of the entire proceeding, and others, they just oppose it and they tell us not one thing.
Yeah, no, sure.
So it's kind of
Yeah.
too bad. Okay.
I think they're associating the second street frontage as the street that is intersecting Forest, which does not count as a second street.
Nice try.
Got it.
This one I forgot about this.
Right.
Go ahead. Oh, go. Sorry. Item number 8, 4006 BZ, 10 Hanover Square, Manhattan.
There are no hearing notice requirements for PCE term extensions. Community Board recommended approval. We have Department of Investigation sign off for the complete body, which is the name of the entity. The statement of facts I found has a very confusing history of the use, so I just wanted to clarify. This is an application to extend the term of a 7336 special permit that was granted in 2006 after what was an accessory PCE use was made available both exclusively to Goldman Sachs employees who were located off-site and then exclusively on-site to residential occupants. I'm not clear whether the establishment is still restricted to only these participants or
No.
whether now it's open to the public. They said nothing. The statement of facts was very confusing. This is also a change in operator that took over in 2012, hence the complete body. The proposed hours are different than those that were approved, so just to kind of note to council, it's not a big difference. I think it's a 30-minute difference. The drawings seem to be missing doors into some of the spaces. They need to clarify, as was done, they should use the last set of approved plans as the model. That set of plans indicated the areas that are the subject of the special permit and grayed out the areas that are not. They need to add the same notes on those plans that were on the first set of approved plans and indicate the location of the elevator access to the cellar and the subcellar. I actually couldn't figure out how you get to the subcellar by elevator. And provide proof of functioning and inspected sprinklers and alarm systems.
I believe they're being inspected like this week or something. I think the applicant told me they were having a fire department inspection or someone inspecting the sprinklers. I think it's after Tuesday.
Okay. Anybody else on this?
Move on. Appeals calendar, item number 9, decisions 2017-25A through 2017-28A, 3094 and 3098 Dare Place, and 3093 Castler Place, 3095 Castler Place, the Bronx.
Okay. This case is on for decision, and I just want to make sure that each of the commissioners who is going to opine on this is clear to consider and review the very specific questions that are presented to us in this appeal, because that's how, if it's challenged, if the decision is challenged, the court has to know that we considered those specific questions. So, 1, the question is whether the lot line segments that separate zoning lot A from zoning lot B are a single lot line or 2 separate lot lines, and whether therefore they are both side lot lines or a side lot line and a rear lot line. I just wanted to remind that there, in the record, there's a version where, of the drawings where the lot line, whatever that lot line is, either jogs perpendicularly, so with a 90-degree angle, and another one that has, or another 2 actually, I think I saw another one, that has a diagonal and a curve. Okay, so the second question is whether, depending on the outcome of the first question, both or either sets of buildings, number 2, that's on lot 487, part of zoning lot A, and number 3, which is on lot 500, part of zoning lot B, and buildings number 1, which is on lot 489, part of zoning lot A, and building number 4, which is on lot 488, part of zoning lot B, meet the zoning resolution definition of semi-detached buildings. So those are the back-to-back buildings that are on either side of that zoning lot line. So the question is, are they semi-detached buildings? And that kind of depends, that totally depends on what your conclusion in number 1 is. And 3, whether the open space measuring 30 feet perpendicular to the rear wall of each of the 4 buildings is required at the site pursuant to section 23-891. So those are the questions that you really need to address. Yeah, so the first one is whether the lot line segments separating zoning lot A and zoning lot B are a single lot line or 2 separate lot lines. And after having decided that, whether they are both side lot lines or a side lot line and a rear lot line. And that has to do with what you think about the effect of that slope, curve, jog, or angle. Okay. So did everybody who's going to look at this understand those questions? Okay. So, and the reason I say who's going to look at this is because we have 2 commissioners who didn't start until after this hearing, these hearings on this case began. So we have, now to get to my comments, so we have another submission from a neighbor concerning the establishment, the official establishment of the mean high water line by the National Oceanographic and Aeronautic, whatever.
NOAA.
NOAA, but I always forget what the last thing stands for. Okay. Although not dimensioned, one image appears to show the mean high water level at the shoreline, more or less where it is shown on the survey. I would suggest that if the neighbors wanted to pursue this subject, they need to take it up with the Department of Buildings, since it is up to a surveyor to coordinate the data obtained from the NOAA with the survey. So at this point, that's not before us, and they kind of look similar to what the survey showed. With respect to, so in my opinion, with respect to whether the lot line is a continuous rear lot line, the zoning resolution section 1210 definition of rear lot line says, is any lot line of a zoning lot except the front lot line, which is parallel or within 45 degrees of being parallel to and does not intersect any street line bounding such zoning lot. So as I mentioned, there's a version of the lot line in the record with an angled line attaching one segment of the lot line to the other. The angle is within 45 degrees of parallel, so I view that as a rear lot line, which converts under section 62-331 to a side lot line since it intersects the shoreline. So that's my response to number 1. Therefore, with respect to number 2, since each set of buildings on either sides of the zoning lot line abut along a side lot line, each set of buildings are semi-detached under the section 1210 definition. A semi-detached building is defined in section 1210 as a building that abuts only one other building other than an attached building on an adjoining zoning lot along only one side lot line, and which is surrounded on all other sides by yards, other open areas, or street lines. So that's my answer to 2.
If I could back up,
Yeah.
what about the other buildings that have let a rear lot line? So you say they're not semi-detached? Is that clear?
What?
Sorry, continue.
Okay. I'm just talking about these 2 buildings.
Yes.
They
Yeah,
abut
yeah.
each other along a side lot line, therefore they're
They are
semi-detached.
Okay.
So with respect to the third question, I don't want to take a long time. I read my comments and reasoning into the record at the last executive section, and DOB submitted something recently, which hasn't persuaded me that there is no conflict between section 23-891 and section 62-331 in this case, where waterfront regulations supersede by the terms of Article, 4, Chapter 6? Is it?
I think it's Article 6, Chapter 4.
Article 6, Chapter 4. Really? Okay.
Article 6 is waterfront, right?
Yeah, okay, Article 6, Chapter 4. So my question is, how can you obey side lot line regulations and rear wall spacing regulations at the same time? You can only be mastered to one set of regulations. I think the particular situation here is very atypical and was not contemplated by the City Planning Commission. Therefore, I believe that 23-891 is inapplicable in this unusual situation. So that's my answer to number 3.
Okay. With regards to 1, I will accept that this is a single lot line. However, and by that definition, then applying waterfront regulation, then this would be treated as a rear lot line, right?
Side lot.
Sorry, a side lot.
Yeah.
It would be, the rear lot line would be treated as a side lot line. Sorry.
Okay.
Then comes to the question of semi-detached. While the text as it reads is correct, the graphics associated with semi-detached have always shown semi-detached buildings abutting the same street frontage, not 2 separate street frontages. So semi-detached have always been 2 buildings abutting each other along a zoning lot line. And as graphically shown in the zoning text, zoning resolution, not even the zoning handbook, the zoning resolution shows that they are abutting each other along a side lot line facing the same street. So by that definition, I do not think this meets the definition of a semi-detached. The third question is then the open space measurement. The way I look at it, I think the both apply, is that the waterfront regulation identifies what is the side lot line. And if you take that as a side lot line, that's one aspect of it. However, then applying section 23-891, it requires an open area to be provided adjacent to the rear wall of each building. And section 23-891 defined the rear wall as a wall opposite the wall of each building that faces a street or private road and requires a 30-foot open area, which in this case can be met. The building has a front on Dare Place and another one on Castle, and so the wall that would be behind that would be the rear wall, and from that, a 30-foot would be measured to provide an open area. So I think that still applies, and at the same time, you could still have the waterfront requirement. So does that answer
Yeah,
the question?
Yeah, it does. That's right, the note's right, but yes.
Yes.
Okay.
So I actually would like to relook at the papers as regards your questions 1 and 2 before forming an answer. Unfortunately, I wasn't looking at it like that. I was actually looking at it in terms of whether or not the fact that the buildings front on a street mean that that's their front wall, and then I define the rear wall in relationship to that. And the rear wall is the wall that is separating the two homes, and so therefore there is no required 30-foot open area there, and so therefore I am more inclined to agree with Department of Buildings in this case, that they don't have the required rear space.
That they do not have it and
They
they
should not have it, and they should have it. So I would like to look at the papers again as regards questions 1 and 2 that you've asked.
Yeah, I actually had the same approach as Commissioner Brown. I believe, I don't think there is a conflict between the said zoning resolution sections, and I looked at it the same way Dara looked at it. We have a street facing two buildings, and I consider them as two semi-detached houses too.
Say it again, so you have a street? Say it one more time?
Yeah, I believe that the two existing buildings could be considered as two semi-detached homes or houses.
Both sets of buildings you
Yeah.
think are semi-detached, got it.
Semi-detached.
Okay, so that's,
That's a yes to the second.
okay, so the second, so number 2 is they are semi-detached buildings?
Yep.
Okay.
And I'll retake a look at the papers one more time.
Okay, for number 3?
Yes, but I'm inclined to go with the DOB
Okay,
letter, the latest submission from the DOB.
okay, okay. Right. And Commissioner Shibeta just arrived, so doesn't know the
I'm going to abstain.
background.
Tomorrow's decision.
Okay. Thank you.
Wonderful.
Continued hearing, may I go on? Continued hearing items, item number 10, 2017-193 to 199A. This is 9, 10, 11, 12, 14, 15, 17 Tupelo Court, Staten Island.
Okay, we have 4 new letters of opposition to the application. I think there might have been some more added very recently.
Yeah.
And their concern is protection of the wetlands. I just need to say that here we are at the Board of Standards and Appeals looking at a waiver of the general city law having to do with unmapped streets, right? We relied completely on city planning and the Department of Environmental Protection for guidance on the subject of the protection of wetlands, which is not our domain. And they have determined to permit development on the site as proposed. The BSA actually has no expertise in the subject of wetlands, and it's just not part of our, as we say, wheelhouse. The applicant submitted a revised Homeowners Association agreement that our council, I think, has been reviewing,
Yeah,
I'm sure.
I've
Yeah,
seen
yeah.
it. Yeah.
Okay, so I haven't had a chance to close down on that whole story. There should be a copy of the August 8th DEP letter stating the scope of New York City maintenance that is attached to and should be attached to the HOA to put all on notice. The reason why this should be included is the Department of Environmental Protection stated very clearly what they will take care of and what is to be maintained by the property owners. So that should be included in the HOA as an official statement. So it's very clear to purchasers. There's an updated and DOT-approved builder's pavement plan showing sidewalk continuity along Richmond Road, but showing no dimensions of any kind on the sidewalks along Tupelo. There's also no sidewalk connection between Richmond and Tupelo shown on the builder's pavement plan. Both BSA and builder's pavement plan should match since contractors, I believe, built to the pavement plan. And so that needs to be amended to show dimensions on Tupelo of the sidewalks and so on, and a connection between the sidewalks and the public streets. We don't yet have fire department sign off on this, which is critical. We asked at the last hearing for a borough president's map and for an access easement for fire department, a separate one, for fire department to enforce no parking regulations and for location of no parking signs on the plans, which wasn't provided. The HOA has a kind of one-liner reference to fire department access, but that doesn't give the fire department the authority that these easement agreements, separate easement agreements do. That separate easement agreement actually gives the authority of the fire department to enter and cure. Whereas this little one just says fire department can come on the site, right?
You want to
It's not the same thing. So, so we need that. Anybody else on this one?
I'm not,
Please.
while I understand that what our expertise is with regard to wetlands, I'm not exactly comfortable at this point saying that it shouldn't be part of our concern, considering Staten Island and wetlands, the effect wetlands had with Hurricane Sandy, et cetera. I think that we have to at least address these concerns brought by, it seems like most of the elected officials in Staten Island with that area, the community board. There seems to be a lot of concern, and considering Staten Island's very recent history, I can understand it.
Right. So I understand it too. The problem goes like this. A lot of the concerns were, a lot of the submissions that are letters of opposition were submitted to city planning during the city planning hearings for the site plan approval, which we're not involved in, right?
And DEC also.
And DEC.
Had an unusually open public review process on this one.
Right. So there were lots of public hearings and public review of this subject for a very long time. I mean, we're kind of late in the story. And those are the agencies charged with protecting the wetlands. And they do calculations and they figure out, I mean, I don't actually know how they do it, but they talked about that in some of the review. So, so for us to have a comment about whether the wetlands are protected or aren't protected without having in-house expertise about that is kind of, I don't know if it's possible, right? And for the second part of it is that I believe we reached out to DEC, didn't we already? And they said they've already looked at, I mean, they did the work.
DEC, I think, renewed
Yes,
it.
right.
Yeah, they renewed it, so.
So that was a thing. So our question was the initial review taking, if the initial review was prior to Sandy, did they look at it again after Sandy? And they basically reaffirmed their position, right, after Sandy.
I didn't see that.
That was my understanding.
Right,
We'll
that's,
take a look. Going back to old notes. Yeah, DCP in 2013 approved the site for special natural area compliance, and a DEP easement area was created to protect it. So that was after Sandy. Those are my notes.
yeah. No,
Yeah.
Right?
Yeah.
So that's the thing, and you would think that city planning, in this case, city planning would have been on heightened alert and would have relooked at this. Perhaps they didn't, but then that's a question I would think that the community would then be going back to city planning or DEC or DEP and saying, we protest the outcome and maybe, challenge it. But here, we're only asked to look at whether you can have an unmapped street.
I'd ask that at least the electeds who have submitted opposition letters be noticed of the hearing date. So I know, well, I'm not sure if they already are noticed of the hearing date.
They are noticed of the initial hearing date, and then, then they have to follow up,
Okay.
like everyone does who comes to the initial hearing. And we're in constant contact with the borough president's office. They send us emails constantly about all the projects in Staten Island. So, and has certainly sent additional letters of opposition over time. Did you have something you want?
Yeah, no, I just had, with regard to the HOA that was submitted, the revision was submitted on March 7th. It refers to multiple schedules, and one of the board's questions, the last hearing was about the ownership of Tupelo Court. And so Schedule A is said to describe the real property initially subject to the application, to the declaration, sorry. Schedule B is supposed to outline the access easement for association members, and Schedule C is about sewer lines and utility poles. If those three schedules could be provided for our review, that would be very helpful.
Just my note shows that we did, there is an FDNY sign-off. That's,
Really?
yeah,
Oh.
the initial
I didn't-
submission.
I thought
That's
we
what
wanted a
was in my
revision.
note.
I'll check that.
So if you could check that.
I thought we wanted revision, all right.
Oh, no, actually, well, so the fire department wanted a revision because the turning radius wasn't large enough.
Okay.
And so then we didn't have a sign off saying we're good with the turning radius. I think this is the one.
I think that's,
sign off.
yeah.
Yeah.
So we're looking for one more final letter.
Yeah. Okay, and then, and the other aspect of it is, my understanding is there's no parking along the entirety of Tupelo.
Oh, right.
Which is not actually labeled as being entirely no parking, only the turning radius is. And so we need fire department to be clear about where no parking is permitted, and then that's why the fire department easement has to make it clear that fire department can literally come on and, if necessary, move the cars, right? Or yeah, somehow or other, self-help. Because that's a big issue for these unmapped streets. Okay.
Move on. New cases, item number 11, 10215A, 1088 Rossville Avenue, Staten Island.
And this one, I didn't find proof of service of initial application. I don't know, but did find green cards for the notice of hearing to officials. So if the applicant could make sure we have both. However, as proof that there was proof of service, Community Board issued a recommendation, so it must have happened, right? The recommendation was to deny, stating that Rossville Avenue is heavily trafficked and that it will be widened. We don't have anything from DOT on this, so don't know whether the Community Board is correct, and where did they get that
DOT has signed up on
impression?
it.
You got a DOT sign
Yeah.
up? I didn't
DOT
find one.
signed up.
Really?
Yeah.
Oh, okay, so I don't know where the Community Board got that impression. I didn't find the details, but I could have been looking at an old folder. They also state, the Community Board also points out that there should be 3 parking spaces, not 2. So with respect to that parking question, I don't understand the calculations that are shown on the drawing. The calculations state that the existing noncompliance of 1 space for 1 dwelling unit means that a two dwelling unit building can therefore have 2 spaces. That's not how you do the math. So you have 1 non-complying space, true, for 1 dwelling unit, and 1.5 spaces for the new complying one. That's 2.5 spaces. You round up to 3. That's how it's done, so it's 3 spaces, so the Community Board's right. I also didn't understand the notations that there's a request for a side yard waiver. I didn't understand where the non-complying side yard is that they want to waive. Isn't this a corner lot if both Poplar and Rossville are streets of record? So the purpose of the 7301G waiver is to allow the property line instead of the street widening line to be the line from which front setbacks are measured. So side lot waivers are not usually within the scope of the 7301G unless somehow or other they get implicated by that widening line. Sometimes they probably do. There are widening lines in all sorts of strange places. But and I'd like to understand further the waiver of curb cut alignment materials that were submitted. Kind of interesting, but I didn't know what they meant. So just to explain that.
Though I said in my note, I have it written as DOT has no issues, but again, I went back to the folder and I couldn't find it, so.
Okay.
Sometimes
it gets, we read so many cases, you remember?
I take that back.
Okay, so I didn't see a DOT sign off, and the fact that the community board said it's going to be widened sounds like the community board has been trying to get Rossville widened. So, who are usually the sort of the initiators of those kinds of actions. So I don't understand.
There was also mention of it being a daycare center. I didn't see anything from, in any of the plans or anything that suggested there would be a daycare center, so I'd like to...
But that's also not before us for review, and it could be a home occupation. It might qualify under home occupation and a permitted use, so...
I'm sorry, the initial, that's it, I'm sorry.
Go ahead.
There wasn't a daycare center, and that's why the community board was a little opposed to it also.
There is a daycare center?
I don't know if it's still there, but it's on the second floor. It's a small one. It's a small one.
Yeah,
So is it a legal use? I mean, it's not before us, but when we see an illegal use, then we say, or if it's illegal zoning or something like that, right?
Yeah.
But
I was also looking at the traffic portion of whether that be more of a traffic concern, also considering how much that use would be with that lot. That'd be too much use for that lot. Because I know parking and traffic were concerns here.
Well, but for instance, there's a parking requirement for 2 dwelling units, right? 3.
Right.
There must be a different parking requirement for a daycare center, different, right?
Right.
So if the use is different, then the parking has to be supplied. And if the use is a legal use in the zoning district, good. But then it has to comply with parking regulations. So,
Actually, the BP builder's pavement plan showed 3 parking pads, 2 access from Rossville and 1 from Poplar.
so maybe they responded by adding a parking space? Because the zoning regulations, zoning calculations showed 2 spaces.
Right, you're right.
So that's what I was looking at.
So that was one of my comments, that
Okay.
there is an inconsistency in the BPP and what is being stated and the community opposition, so maybe they addressed it. That would need to be clarified. And I would like, I mean, just in terms of the parking requirements, it would get affected by the use, and the question is this a home occupation? And then if it's a home occupation, how
Then
does
it's
it get treated towards the parking and other things?
Home
need to be clarified.
occupation is an accessory use to a home.
Right,
Right.
so.
Okay, so. Sorry, one second.
Okay, just, is it okay? Okay, oops,
Okay.
sorry. Oh, sorry, I don't want to close it out, yeah. No, yeah, close it out, because you can go back to yours now. Done? Item number 12, 2017-285A, 200 Amsterdam Avenue, Manhattan.
Okay, I'm recusing from this application.
Yep. Ready? Okay.
Okay. So it's going to be a long read. Please bear with me. At the outset, I want to say that we have received a very thorough, comprehensive document from all parties for our consideration. This is a complicated issue, so we thank you for this thorough analysis. So I want to start off with the background. The appeals case before us has been made by Committee for Environmentally Sound Development requesting that the board revoke the building permit issued by DOB on September 27, 2017 for a new construction at 200 Amsterdam Avenue, for which DOB had initially issued an approval for construction of a new building on the subject zoning lot on May 9th. Per DOB rule, the ZD1 was posted on the department website, where members of the public are allotted 45 days from the date of posting a zoning diagram to challenge a department's zoning diagram approval, which is ZD1. On May 15th of 2017, appellant challenged DOB ZD1 approval, raising among others the following issues. Zoning lot does not comply with open space requirement. The existing parking lot and driveway do not qualify for inclusion in calculations of open space, and parking in the rear yard behind the subject building is not a permitted obstruction and thus does not qualify for inclusion in calculation of open space. On July 11th, 2017, DOB issued a ZRD1 CCD1 response form. DOB accepted appellant's challenge concerning whether the zoning lot was properly formed in the course of the 2015 subdivision and that the open space provided do not qualify as open space as per zoning resolution sections 1210, 2363, and 2344. DOB subsequently issued notice of objections special audit dated July 28, which was directed at the 2015 subdivision and raised questions based upon the fact that some of the tax lots within the zoning lot are not entire tax lots, and requested verification as to compliance of the buildings on the zoning lot with applicable bulk regulations of the zoning resolution. The owner of 200 Amsterdam Avenue responded to the objection. DOB accepted the audit, rescinded the notice to revoke on September 26th, and issued a permit on September 27th. Subsequently, on November 17th, DOB posted a ZRD2 response to the zoning challenges, indicating that DOB disagreed with the challenge. Appellant filed an appeals on January 11th, requesting revocation of the building permit issued by DOB. So there are two issues before us on the appeal, for appeal. One is whether the subject zoning lot resulting from the 2015 subdivision meets the definition of zoning lot in section 1210 of the zoning resolution, and whether the subject lot complies with all applicable open space requirements. So I'll start with the zoning lot. Appellant argues that the subject zoning lot on which the new building is under construction does not comply with the requirements of the definition of a zoning lot in section 1210 of the zoning resolution because it does not consist of lots of record, meaning the entire tax lot as shown on the official tax map of the City of New York. For clarity, the subject zoning lot comprised of various tax lots and portions of tax lots. In assessing appellant's assertion regarding the zoning lot not being compliant with the requirements of the definition of a zoning lot, we must refer to the plain language of the zoning lot definition. Zoning lot definition under section 1210 must be either of four types. It does not have to be all because the word or is used to separate the subparas. For this subject lot, DOB analyzed the zoning lot pursuant to subpara D, which is a tract of land either unsubdivided or consisting of two or more lots of record contiguous for a minimum of 10 linear feet located within a single block, which at the time of filing for a building permit or if no building permit is required at the time of filing for a certificate of occupancy, is declared to be a tract of land to be treated as one zoning lot for the purpose of this resolution. Neither subparas A, B, C, or D refer to tax lot. Zoning lot definition refers to a tax lot. Zoning lot definition refers to a lot of record, which is not a defined term. It also refers to a tract of land, which is also not a defined term. The zoning lot definition further states that a zoning lot, therefore, may or may not coincide with a lot as shown on the official tax map of City of New York or on any recorded subdivision plat or deed. So, if the zoning resolution wanted a subpara A to refer to tax lot, it could have used the phrase tax lot, also subparas B, C's, and D's state a tract of land either unsubdivided or consisting of 2 or more contiguous lots of record. Hence, a tract of land that does not consist of 2 or more lots of record contiguous for a minimum of 10 linear feet may still qualify as a zoning lot under subparas C or D if that tract of land is unsubdivided, which could simply mean not yet subdivided into or ascribed to another zoning lot. This would lead one to conclude that the tax law did not constrain zoning lot to be a lot of record. Furthermore, a tract of land or a lot of record need not coincide with a full single tax lot. The legislative history of the zoning lot definition is consistent with the plain language of the 1210 definition. Since 1916, the zoning lot text has used a parcel or plot of ground to a lot of record or a tract of land, as in 1961 zoning text, to define a zoning lot. The 1961 definition defined the zoning lot as either A, B, or C under single ownership. The text further clarified that a zoning lot therefore may or may not coincide with a lot as shown on the official tax map of the City of New York or on any recorded subdivision plat or deed. And the text also factored in zoning lot subdivision by affirming that a zoning lot may be subdivided into 2 or more zoning lots, provided that all resulting zoning lots and all buildings thereon shall comply with all of the applicable provisions of this resolution. The 1977 text amendment added subpara D for the sites where parties in interest had interest in different parts of land delineated as zoning lot. The purpose of subpara D was to prevent overdevelopment or prevent what I would call double dipping into the same parcels of land towards generating floor area for more than one zoning lot. The 1977 text built in necessary safeguards to prevent overbuilding or double dipping by including and binding all parties of interest pertaining to a zoning lot. As in the 1961 text, the 1977 text also continued to not coincide zoning lot with tax lot. This further emphasizes that tax lot is not the same as lot of record. Zoning lot may include a part of tax lot, otherwise the drafters would have used the term tax lot instead of lot of record or tract of land. A point to be noted, even when using the term block, the text, zoning text did not associate it with city tax map. Instead, block is defined as a tract of land bounded by streets, public parks, railroad rights-of-way, airport boundaries, pier head lines, or the corporate boundary lines of New York City. So the text has been consistent in not coinciding zoning lots with official city map. Additionally, evidence in the legislative history of the 1977 amendment supporting the plain reading of the text that a tax lot is not coterminous with a tract of land or lot of record is a memo dated December 28, 1987 from the Department of City Planning Counsel, William Valletta. It states the definition of zoning lot was the essential building block on which the bulk calculations of the zoning resolution were intended to be calculated, and the definition went on to say that the zoning lot may or may not coincide with the tax lot, as it does in the 1977 text. The 1987 memo cited us to a Supreme Court Appellate Division case affirming a ruling that the subsequent sale of one tax lot in a merged zoning lot, subject to all the restrictions that result from the use of its excess bulk on another tax lot, does not violate the zoning resolution. Valletta writes that it is therefore clear so that so long as a zoning lot remains consistently fixed, the free alienation of the tax lot is not affected. Valletta concluded that the actions fixing a zoning lot, which results in conforming and complying situation, is separate and distinct from sales of the lot or its constituent parts, emphasizing the constituent parts. With regards to administrative implementation of the 1977 text amendment regarding the zoning lot, Department of Buildings issued a memo dated May 18, 1978, referred to as the Minkin Memo. The intention of the memo was to provide guidance and forms acceptable to implement the definition the zoning lot. It summarized the applicability of 1977 adopted zoning amendment regarding what constitutes zoning lot. The memo is explicit, quote, a single zoning lot which may consist of one or more tax lots or parts of tax lots, and in referring the acceptable forms, Exhibit 2 certification pursuant to zoning lot subdivision D, it reaffirmed that the boundaries of such zoning lot may or may not coincide with its comprising tax lot. So based on both the Minkin and Valletta memos, it is clear that for me it is clear that the purposes and thus the definition of the zoning lot and tax lots are different. Zoning lots serve as the basis for applying all zoning regulations independent of their constituent tax lots or parts thereof. I'll also note that that Department of Buildings interpretation of the zoning lot text has been applied consistently both citywide and at the subject site for the last 40 years. The Minkin memo had an extensive outreach to practitioners. It was distributed throughout DOBs, city planning, organizations, representatives, professionals involved in the development process, and to title insurance industry. Not only is the Minkin memo explicit, DOB's practice in permitting projects and issuing COs for the projects on zoning lots comprised of parts of lot is clearly evident. Apart from its application throughout the city, on the subject superblock, DOB has affirmed the interpretation on 6 occasions since 1987. So this would affirm DOB's consistency in its application of the zoning lot that may consist of one or more tax lots or part of the tax lot. And finally, as a board, in considering this appeal, we also need to be consistent with prior board determinations. And with respect to a 2006 appeals in Breezy Point, DOB had taken the position that for the purposes of applying the zoning resolution, each plot within Breezy Point is accepted as a de facto zoning lot as defined by the zoning resolution section 1210, notwithstanding the fact that the plot at issue was only a portion of the Breezy Point Cooperative's larger single tax lot. In that situation, BSA had denied the appeal upholding DOB's interpretation, and BSA's resolution was upheld by both the New York State Supreme Court and the Appellate Division. Now I'll move on to the second question that was raised, that is with regards to the open space. Appellant states that even if the subject zoning lot were not improperly formed, a substantial portion of the open space on the zoning lot does not comply with applicable open space requirements. The appellant argues that driveways are not accessory to the subject zoning lot and thus is not a permitted obstruction in an open space. And the requirements of sections 2312, 2344, 2552, 2564 regarding permitted obstructions and accessory parking are not met. Based on the plain language of the zoning resolution section 2312 identified the elements that are permitted obstructions in an open space. Per zoning resolution section 2312, which is permitted obstructions in open space in R1 through R10, driveways, private streets, open accessory off-street parking spaces, unenclosed accessory bicycle parking spaces, or open accessory off-street loading berths shall be permitted in any open space required on a zoning lot, provided that the total area occupied by all these items does not exceed the percentage set forth in zoning resolution section 2564. 2564, which is regarding restrictions on use of open space for parking, restricts the use of the open space specifically in R6, R7, R8, R9, and R10 districts without a letter suffix, driveways, private street, open accessory off-street parking spaces, unenclosed accessory bicycle parking spaces, or open accessory off-street loading berths may not use more than 50% of the required open space on a zoning lot. The text in both sections is clear and consistent in its application of the term accessory. It has been used in the context of parking lot, bicycle parking space, and off-street loading berth. The word accessory does not apply to driveways and private streets because it is absent as a modifier. Driveways serve many purposes, not just provide access to accessory parking spaces. Thus, the text did not insert a modifier to driveways and private streets on purpose because they need not be accessory. So regardless of whether driveways are accessory to or not, driveways can be included in the calculation for open space. Now, the Elkis-Manfredi Architect Plan ZSK1, which was dated April 19, was stamped and approved by DOB. That plan indicates the obstructions within the open space, which consist of only driveway areas totaling 16,157 square feet, equaling about 18% of the required open space, and therefore it would be less than the 50% permitted obstruction per zoning resolution section 2564. With regards to accessory off-street parking as permitted obstruction in the rear yard, zoning resolution section 2344, parking spaces for automobiles or bicycles off-street open accessory within side or rear yard are permitted obstruction. In addition to any rear yard or rear yard equivalent, parking spaces off-street accessory for automobiles or bicycles is permitted, provided that if accessory or accessory to any other kind of buildings containing residences, the height of a building or portion thereof containing such parking spaces within the rear yard shall not exceed 15 feet above curb level or base plane as applicable in R6, 7, 8, 9, and 10 districts. There are two parking areas in the subject zoning lot: a below-grade accessory parking facility at 200 West End Avenue and a parking area at grade behind the subject development site. The owner has stated that this parking area is neither owned nor operated by the owner, and there is no record of their construction or operation having been approved by DOB. According to the May 19th plan of the Elkis-Manfredi, 77,642 square feet of open space is required on the zoning lot. According to the plan, 86,972 square feet is provided. Owner is stating that with the elimination of the parking in the rear, which occupies about 6,622 square feet, zoning lot would still comply with the required open space. If the parking in the required yard is not accessible to the new building, it is not permitted obstruction in a required yard and therefore should not be included in the open space calculation. DOB states in their submission that to the extent there are to be parking spaces in the rear yard of the proposed building, the applicant must remove them or submit revised plan to reflect this legality. So my question to DOB is this parking lot intended to remain open, once construction is completed? And they are not on the DOB approved plan. DOB can confirm that. And if so, has the property owner submitted revised plans to DOB addressing the parking in the rear yard? Can DOB confirm that the permit will still be valid if this parking area that is not accessory to the zoning lot is eliminated from the open space calculation? The second point the appellant had raised was that the requirements of the definition of open space, section 1210, to be accessible and usable by occupants of the new building dwelling unit is not being met. Per zoning resolution section 1210 definition of open space is that part of a zoning lot, including courts or yards, which is open and unobstructed from its lowest level to the sky and is accessible and usable by all persons occupying a dwelling unit or a rooming unit on the zoning lot. The terms accessible and usable is not a defined term in the zoning resolution. Since the subject lot is not a large-scale residential development and does not qualify as one, provisions of section 7852, common open space that is not applicable in this case as referred in appellant's submission. Nor should we infer the intent of accessible to and usable to from section 7852 for the subject zoning lot. Furthermore, the owner states that a recorded 2005 declaration ensures that the open space will be accessible. In a prior application before the board, BSA calendar number 3408, DOB had represented that the validity of a permit is based on, among other things, a demonstration of compliance with open space requirements, that neither the zoning resolution nor DOB practice requires an applicant to provide an additional guarantee that open space will always be made available to occupancy. That is, the zoning resolution does not require an applicant to ensure the public's right of access to such open space as a precondition to the issuance of a permit on a zoning lot with multiple buildings, and that DOB confirms compliance with the open space requirement when inspecting the site prior to the issuance of a certificate of occupancy. I want DOB to confirm whether that remains their position, whether the accessibility of open space is determined at permit issuance stage, or whether at the time when the premise is inspected for the purposes of issuing a certificate of occupancy. In this case, I think DOB's position based on their sign-off is that the owner has stated that the open space will be open and accessible as required by 1210 definition. Thus, to say that an open space will not be accessible at this stage is speculation without evidence. And finally, the appellant had also questioned the general standard of the required open space on the zoning lot. The required open space for this zoning lot is being determined pursuant to open space ratio calculation. No one disagrees with regards to the total amount of required open space, which is 77,642 square feet that would be required. So the interpretation of the zoning resolution section 23-151 at the subject site is not in question before us. At the same time, the zoning resolution is silent on general standard or minimum dimensions required for an open space. The only number associated with the required open space for the subject lot is related to the total amount of required open space per section 23-151 and per 1210 section, which is regarding location of open space above curb cut and amount of open space that can be covered. Please note that where the zoning resolution wants to institute a minimum dimension for open space, it knows how to do so. And in the 1210 definition with regards to open space provided on a roof, the zoning resolution was explicit in saying that such open space, for instance, have to have a minimum dimension of no less than 25 feet, except in the R8, R9 districts, where such roof area joins a street line or a rear yard. It may have a minimum depth of 9 feet and a minimum length along such street lines or rear yard lines. None of those have been clearly stated for any of the other situations other than just for the open space provided on the roof. So I just want to note that. So I think based on DOB, what DOB has reviewed, what I have reviewed, and DOB has issued they issued a notice of objection on June 23rd following the zoning challenge regarding the proposed obstruction to open space being less than 50% of the total open space on a zoning lot pursuant to Section 2312 and 2564. The owner provided a response which DOB reviewed and accepted. So based on the plain language of the relevant zoning resolution text and the legislative history, I so far am of the opinion that DOB has issued the permit appropriately. So I will, I know it was a lengthy one, but the appellant was very thorough and there were a lot of points, so I wanted to make sure I went through each one of them.
I'm not sure if you mentioned a very important point by DOB, which was that they were not necessarily going to keep their current interpretation of zoning lot and might actually in the future actually they are currently revising their paperwork and revising their definition to encompass the whole idea that a zoning lot cannot be made up of partial tax lots. And I think that's kind of an important part that you actually left out because you didn't really discuss the position that DOB actually took.
That's a good point you're raising. The reason I didn't raise it because DOB, while it recognized in its letter, in its submission that they are considering it, they also indicated that the Minkin memo still has not been rescinded, right. And it's a draft bulletin, and they are.
I just was saying you should just have presented the entire position so that this way everybody understands. But I do have a number of questions that I wanted to ask.
Commissioner, can I speak to that first one?
No, because I want to first go through the questions that I have.
Yeah.
So for me, the issue here is what is the lot of record and its relationship to whether or not the zoning lot was properly formed. It's important to note that the term lot of record is an undefined term. And so, therefore, I'm not convinced that lot of record refers solely to zoning lot and not to tax lot, and in fact solely to tax lot. And the reason why I state that is because the lot of record, the word record is in that, and to record is actually a verb that's used at City Register in New York City Department of Finance when referencing tax lots. And so therefore, my question is, and this is a question to both the appellant and as well to Kramer-Levin and also DOB, is there any other instance of recording either within Department of Building or within other agencies that would lead one to believe that they weren't referring solely to tax lots and that zoning lots were actually and are currently actually recorded? I know that since 1977, the agreements regarding zoning lot formation, mergers, apportionments, are actually recorded in the City Register and Department of Finance. But when this text was actually made, originally, lots of record, the term, it wasn't really referring to recording of zoning lots at Department of Finance. So in order for me to accept that that term actually meant zoning lots as well, I would need to have some background as to lots of record and whether or not these documents were actually recorded in any other way. I have a question for Department of Buildings. Because of Department of Buildings paperwork that actually indicates that they are actually going to correct an erroneous interpretation of what constitutes a zoning lot, they also then go on to say that they will not reverse themselves and revoke the permit. And I have a question about that. Why, in this case, when changing your interpretation, you are not then going to revoke a permit that's based on an old interpretation? Department of Buildings has had a history of stating that they are not stopped from correcting an erroneous interpretation and then revoking permits if necessary because they were based on an older incorrect interpretation. So why, in this case, are they not willing to do that? So that's my question for them. I have a question for Kramer-Levin's papers in that they spend a lot of time arguing that a possibility of DOB's reversal of their previous interpretation and the revoking of permits would be arbitrary and capricious. And my question to them is, we're supposed to be strictly interpreting whether or not we feel that the arguments of the appellant are valid as regards our interpretation to the zoning resolution. I don't know that we're necessarily supposed to be considering fairness and arbitrary and capricious arguments. I feel that those arguments are probably better served as the basis of a good faith reliance case on the BZ variance calendar, and I would like to hear their views on that. And then finally, and this is more of a comment rather than anything else, the Kramer-Levin paperwork talks about policy, the lack of adverse policy implications when you are actually determining lots of record to meet zoning lot, which would mean that there could be parts of tax lots included. And I disagree with their point that there would not be any adverse policy implications. I don't think that the drafters ever considered what could possibly come from allowing parts of tax lots to be made into different parts of zoning lots and the inability to actually monitor the formation of zoning lots and the then dissolution of the different boundaries and then formation of new zoning lots. And so I think actually there are adverse policy implications to the allowance of partial tax lots to be included in the formation of different zoning lots. It would be very hard to monitor the situation and to ensure that zoning compliance is actually achieved when you've got all these different parts that are parts of different zoning lots that are forming and unforming. And so that's my comment about that. I think there are adverse effects to that policy. So I actually think that a policy reinterpretation or change by DOB is actually indicated and actually is a good idea here.
I think we are not going to weigh in on DOB's in-house determination as to how they're going to handle their policy, but, and I'm definitely not going to, weigh in on this with regards to revoking a permit based on improper application of the zoning law definition, because I'm not going to opine on that, because it will have a massive ramification of adopting appellant's position. And I'm also not sure whether this can be done just through a bulletin. That's my personal
Well,
opinion.
actually, this has been done before. Unfortunately, there have been cases that have both come before us and also solely before DOB, where DOB has actually changed their interpretation and then revoked permits, and it has had citywide implications. And so I just want to know why different. And as I said before, my questions are really not addressed to you. They're addressed to the appellant and the respondent in this case.
Sorry.
I just had a question. I didn't see that the Department of Buildings, I saw a draft memo where they are considering changing their position, but I didn't see that they changed their position on it or are certain that they will change their position on it. And further, I think that we're not necessarily, I don't think they're changing a position determines our decision on the matter either.
Are you referring to my statement?
Yeah, I was just
No, my
wondering.
statement actually was that when we're discussing an appeal, it's important to actually explain all
I
the
see.
different positions, and so that's what I was just clarifying, because the entire position of DOB was not explained.
Got it.
Whether or not it's agreed or not, it should still be stated for
Agreed.
clarifying the record.
I agree. That for the record, please.
Yeah. Commissioner Shida, do you have anything? Okay.
Anyone else?
No.
I just want to let everybody know that we did receive a lot of several letters supporting the appellant's position, including civic groups, elected officials, and the residents. So I expect there will be a lot of speakers on this matter. So I want to remind everyone that the remarks will be limited to no more than 3 minutes, and we will be adhering to that timeline for the public speaking. Ada? I gotta wait for Marjorie to come back.
I think Jonathan should.
I'm going to go get her. Good.
Do you want to just take a break when we go? Should we just take a break? Because we have to get Marjorie back. Should we take a break? Because we have to get.
No, she's gonna be
She's
back.
right out.
She's right there.
You better
Do you
not.
want to take a quick break while she's settling in?
It's up to you
Wait,
guys.
is she here?
Okay.
Wait, is she
Do you
there?
want to do
Typically,
it?
don't take breaks during the.
Yeah, we don't.
We don't
We
take
just
breaks
keep
during
going.
the work session. We just want to keep going so we can get out of here.
That's true, I forgot.
Do we want to keep going, or what do we do?
Yes.
Well, she
As soon as the chair returns, we will continue.
So we want to, because the question was for questions.
What do you got in the drink? Just water.
Just water, yeah. Stay hydrated.
I'm just going to shut the camera. Okay, sorry. All right. Ready. Ready, Madam Chair? Mm-hmm. Zoning calendar, decision items, item number 13, 275-15BZ, 115 East 97th Street, Manhattan.
lots of notes.
This is gonna.
Oh, here we go, okay. I know there was a submission at like 9 a.m., which has calculations on it that therefore I can't possibly review between 9 a.m. and, you know. But anyway, so I'm going to talk about the submission that was from March 8th, that their lot coverage calculations are incorrect on that March 8th submission on P-003, as they don't take into account the residential lot coverage of approximately 4,972 square feet, which you need to add to perhaps the full lot coverage of the community facility building, which is 13,554 square feet, which when added together exceeds the allowable lot coverage for the entire zoning lot located in the R72 of 17,052 square feet. So the definition of lot coverage states that for the purposes of computing height factor, the portion of the building covered by a roof that is used for open space is not lot coverage. However, that's for purposes of computing height factor. I don't know whether that section is applicable in this case, since the lot coverage regulations for the community facility are not height factor regulations. Section 24-12 states that only levels below 23 feet above curb are excluded from lot coverage. So at the same time, the height factor residential building is relying, which is on the same zoning lot in the R72, that is relying on open space that sits on the roof of the community facility. So what I don't know the answer to is it okay to double dip like that when the community facility regulations don't apparently give you any direction there? So that's kind of a DOB call, not kind of, a DOB call. I might say that, you know, so they're off by about 1,000 square feet. It's 18,526 and they're allowed 17,052. So 600 square feet or something like that. So the one idea might be, you know, proceed at your own risk. And if DOB says you can't do it, then you need to amend the drawings to remove that much 600 and something square feet of lot coverage. All right, yeah. That might be one way of approaching it. I know that they tried to get some sort of review from DOB, but they haven't been able to get it right.
So they're getting, they're not getting a ZRD1, but they revised the lot coverage calculations.
Right,
which
but
was sent
I
to
looked at those quickly, and it's still the same question. So I see that what they're doing is, even though they're not doing it clearly, so that's the other thing I wanted to ask. So they need to make very clear in their lot coverage and their open space, they have two separate diagrams for that. They don't tell you where they derive the authority to use that, you know? They just say, the open space is this, because here's open space on the residential and here's open space on the roof of the community facility. But they don't tell you by what sections give you the authority to count that open space. So it's kind of out there in the wind, right? So unless they show a clear breakdown for, on the open space drawings, where they get the authority to rely on open space on top of the community facility, that's one. And then where on the lot coverage diagram, where they rely on the right to exclude lot coverage from the community facility, right? I don't, they're not explaining it clearly enough. And so DOB won't understand, and they may think that we waive lot coverage, and we need to be very clear we are not waiving lot coverage because it depends on the residential building. You know, some of that coverage is caused by the residential building. So, so that's one of the things that I wanted to make sure that we're crystal clear that we are not we're not, yeah, we're not waiving lot coverage, and we're not opining on whether the lot coverage calculations are accurate, right?
Okay.
So, but I'd say they need to be really careful, because I'm not sure that they're allowed to do what they're claiming, because if you look at the community facility regs, it says only the area that's below 23 feet is allowed to be excluded from lot coverage.
I think this gets into the technical matter, which is more in the DOB's purview.
Yeah.
So we should let DOB make that determination
Right.
once we approve it. And
So we had asked them to go quickly to DOB and try to get a determination, which they were not able to do.
They got email suggestion to deduct the open space. from
Right,
on the
but they
roof.
didn't, getting a suggestion that's kind of like a
But
little off-the-cuff suggestion
based
is
on
different
12
than
to 10.
detailed calculations that show how you're relying on the sections in the zoning resolution,
which I
right?
think would be, I mean, in all fairness, this being such a complicated project, DOB will have to review thoroughly.
Sure.
And I think at this stage, to ask for it on a project that is not fully approved, maybe ask, I mean, it's a risk the applicant has to take.
Well, that's the thing.
And then submit all the plans to DOB. We can make it very clear that we are not waiving the lot coverage, and it's between DOB and the applicant to make that documentation very clear and proceed accordingly. And if they need to come back,
Well,
they'll come back.
no, but I would like them, because they can, give us, correct those two submissions that they made at 9 AM and make the calculations super clear about how they're coming to the conclusion that they can use open space, which is one set of regulations, unrelated, right? So there's the open space ratio, which you use for height factor building, and then there's the lot coverage regulations that you use for community facility, and the only extent to which they overlap is that you find out how much lot coverage there is for the open space ratio calculations, and then you can find out what's excluded from the calculations by the text, from the text. And that's the part where I think they may have a problem, not in the open space ratio calculations, but in the community facility lot coverage regulations. The reason I'm not that concerned is they're off by 500 square feet. So you could probably do something about that, and they may need to be just more careful in their math, in their measurements, it could be that. So,
And I also want to mention, sorry, they are getting a revised objection sheet.
yes, right, so they need a revised objection, so we're not, there's still open issues, because they took out the tower coverage analysis now, and they're relying entirely on a height and setback building, so they need different objections. And I'm not sure that we have DOT sign off on the curb cut.
Yeah,
Is that
they
a
found,
sign-off email?
well, they said that it is okay with them. Their
Okay.
response is okay.
Even though there's only 11 feet between the curb cuts.
Yeah,
Okay.
so the email is in the,
Anybody else on this one? Nope.
Are we reopened?
Huh?
Are we reopening?
We might reopen tomorrow.
We'll have to reopen to discuss the lot coverage unless they can just figure it out, right? They really just need to amend the calculations to be super clear, and submit, which they could do.
Okay.
Okay?
Okay.
Is there anything else you want to do?
Jenna, you have anything else?
No? Sure? Okay. She had that expectant look on her face, okay. Okay.
Okay, continued hearing items. Item number 14, 5602BZ, 317 Dayhill Road, Brooklyn. And item number 15, 1-96BZ, 600 McDonald Avenue, Brooklyn.
We got a submission on Friday at 5:30 or something on this, which was what we instructed them to do. Unfortunately, the parking study that so our last hearing on this was March 6th, so we didn't give them a lot of time to conduct the parking study, and they were able to attend on 2 days when there were events, the 14th and the 15th of March. And we had asked that they compare 2 event days to non-event days, so we could establish scientifically that the parking problems are caused by the event space. They weren't able to do the non-event day because of the snowstorm, and so they're supposed to be doing it today. But they submitted to us none of the data that they had collected from the 14th and the 15th, so we actually don't have any information about what they learned, which I don't understand, because that's done with clickers and tab sheets and all that stuff. So if we had gotten the data, we would have been able to look at the data and come to some understanding of what it is, even if it's just for the 2 event dates, right? So I would like submitted to us at, let's say, tomorrow morning, the results of today's study. Apparently they're doing a no event day study from 5 p.m. to 11 p.m. And so the results of today's study in the tabulation form and the sort of what they learned on the 14th and the 15th, that information should have already been distilled and put into some form that we're used to looking at. That needs to be submitted to us tomorrow morning. And the parking consultant must attend the hearing and summarize for us what was observed. No excuses. That must come tomorrow. I also like to understand the status of the rezoning application. Lucats just shows that there was an EAS filed in December, and I don't know what the status of the application is. And if fire department has any comments, to make them tomorrow. I know they're doing some follow-up in a couple of weeks. Anybody else on this one?
Item number 16, 15715 BZ, 3925 Bedford Avenue, Brooklyn.
They requested an adjournment.
Third adjournment?
Third in a row. Yeah, third in a row, but let's let them have this adjournment without
A letter?
I think there was an issue with Department of Buildings or something.
Okay, yeah, okay. Item number 17, 2016-4138 BZ, 32327 Avenue of the Americas.
Okay. Have a lot of notes on this, so it'll take a minute to scroll down to, here we go. So we have new letters of opposition preferring scheme C1 because it provides larger residential units. This scheme does not appear to be financially feasible, however, because it requires that construction take place on top of the existing former church building, which was described to us as, at the last hearing, as requiring a near dismantling of that building to do an enormous expense. The concern that the smaller units in the 4D1 scheme will not be appealing to permanent residents is actually inconsistent with recent housing trends, where very small units are being constructed to appeal to singles. That's the first thing, where actually there's movements to try to get micro units that are smaller than what's even permitted under zoning resolution and building code and so on. And anyway, small units of this type are actually typical of many existing tenement and front-rear row house apartments that are found throughout the village. These are actually a little bit on the large size compared to lots of apartments where you break up the row house and there is an apartment in the front that's like the parlor, front parlor in the back. So I actually don't understand why they think that's atypical of their neighborhood. There are actually quite a number of tenement buildings on that block which have very small apartments. There's a February 14th submission, which I believe is the last one made by the applicant, because we had a lot of submissions on this by different people, so to try to keep track. Scheme 4D1 has been revised to include 10 theaters instead of 11, and residential above the first floor on Cornelia Street, for a total now of 941 seats instead of 947. It's considered a feasible project according to the financial analysis. Additional structural data and a revised financial report were provided. I think the layout of 4D1 works much better now, allowing ample space for waiting on the interior of the theater, which was a big concern because of all the overspill onto the sidewalk, and eliminating tight corridors and questionable egress conditions. And it allows for residential frontage on Cornelia, which is consistent with neighborhood character and guarantees an active window condition at the upper floors. It avoids the additional expense of building on top of the existing theater, which was a former church building, which I discussed before, seems to be really an impossible construction cost. Opposition submitted materials as well, although I'm not really sure what the reason for their objection is anymore. Scheme 4D1 is responsive to community concerns. The RAP and Phase 2 submitted on January 9th and February 21 were submitted. I didn't find DEP sign-off there, and I wondered if there's other open environmental issues.
So we have DEP sign-off for the RAP and CHAS. They just have to update the RAP with just what the language is in the sign-off, and it should be in the file. And we need a final EAS with all the sign-offs. And if you remember, this project has drastically changed from the original proposal. So they may have to do just a new shadows analysis.
Isn't it smaller than?
Yeah.
I believe it's taller, right?
Oh, it's taller,
Because of
right.
the
They added a
apartments in the
floor
rear.
on the existing
Right.
small theater
Oh, right,
section.
So anyway, they will just, I think once they have an idea of what the final proposal will be, they will just make sure that the shadows analysis match it, they'll do a shadows analysis based on the final proposed
The
project.
height on Cornelia is still 60 feet. It's only along 6th Avenue.
Yeah.
It has increased slightly.
That was,
Well, I
they added a
believe-
floor on 6th.
But remember, the original proposal didn't have apartments on Cornelia Street, so it was shorter when it was first submitted.
It was? I thought it was always the same height as the
I thought it
tenement
was-
next door. I don't think it's a
Yeah, I
taller
thought the
building.
bulk was 60 feet. I
Okay.
seem to vaguely
Yeah.
remember it
Well-
was 60
But
feet.
it is
consistently.
taller on the 6th Avenue side.
So it's only the shadow analysis. Well,
Yeah,
anyways.
Anyway,
right.
they have to just-
So,
yeah.
and then in that case, then the whole EAS should just reflect the project, is that?
Yeah, they just have
Yeah.
to create a final EAS with whatever the final proposal is. They just have to make that match, the EAS match that.
Okay, but otherwise we have sign-offs from everyone.
We have signs from everyone, just the shadows need to be redone.
Okay. Okay. Great. Anybody else on this one?
No, I agree with you. I think this board has heard very clearly all the concerns that have been raised, the community's concern, the oppositions, and has directed the applicant to revise the plans. And I have to commend the applicant for providing various options and going through different iterations. And finally, I think 4D1 addresses all the concerns that we have heard. The community wanted a residential presence. It provides a residential presence. At the same time, it also ensures that the viability of this use and feasibility of this use is possible, and which is by not providing a theater on top of an existing theater, by allowing a different layout that allows for an enlargement of the theater spaces and a better layout, as we were concerned about, and retains the viability of the theater space while allowing a residential use on the Cornelia scale.
I just want to clarify, though, that this is, because I know that's one of the comments from opposition, that though we talk about a theater, the current tenant is a theater. The building was built as a church and was converted, I think, in the 50s to a theater. So it's been functioning as a theater, no matter who the owner is, since that time. It's been functioning as a public assembly place since its birth, right? And the idea, and we have looked at, so the question is, can the property owner make a reasonable return on investment by converting it to some kind of conforming use? So the first part of it is the lot is split, so you can't actually have a use that's totally conforming on the lot, you'd need to, at the moment of the split, have residential in a part of the building where you can't have part of the building. So that part kind of is obvious that the use, the commercial use, has to extend across the boundary. The next part of it is, does the property owner have an opportunity to make a reasonable return on investment without doing something super aggressive to the building? And we looked at, what could be let's say a viable option other than a theater. And so we said, what if you made it a Dwayne Reed, for example? The theater has raked seating. You would need to rebuild the floors so there's a major investment to stop it from being a place of public assembly, right? So a huge investment to turn it into a retail space when it's already fitted out as a series of theaters, which it's had for decades. So clearly, the most viable use for the landlord is to maintain this tenant in place, right? And to do it in a way that's as sort of peaceful, non-violent as possible, so that the tenant can still operate while construction goes on in the vacant site, right? And construction goes on in that little building that can easily be modified without affecting the main use. I just wanted to clarify that because I know that's come up.
And so, sorry, the height of the theater increased on the 6th Avenue frontage, and Cornelia Street's been the same, so yeah.
Right, thank you. Anybody else?
I don't have any additional questions.
Okay. Anybody else? No?
No, I'm good. I would like to thank the structural engineer. After the discussions during the last hearing, actually his submission was like very extensive and very detailed, so I'd like to thank him for that.
Okay, thank you. Okay.
Item number 18, 2016-4208 BZ, 142 West 19th Street, Manhattan.
1 second. So we had some open items on this application, which were essential for establishing that there are subsurface conditions to support the claim that there is an A finding, which would support the request to vary the height restrictions. We already established that the site is shallow and can support a rear yard waiver, but we were relying on structural information to determine whether they had established a uniqueness, a subterranean uniqueness. The applicant provided additional structural and cost data and revised financials, but I'd like our two experts on those subjects to discuss.
No, actually, as I said last hearing, I did not have any additional questions of a financial nature, and that I would defer to Commissioner Shetta, because if the costs stay as they are, then it is, clear that the proposed is the only viable scenario. However, if the costs are adjusted downward beyond a certain amount, not only is the E finding in play, but the B finding is. And so with that, I would say that the threshold for reconsidering could be as much as if we hit $600,000 in a reduction of costs, then everything would be in play again. So with that, I would actually defer to Commissioner Shetta and try and figure out what the final number of reduction in dollars would be.
Sure. So I'll first go over some sort of history. We started this hearing, I started looking at this case back in October 2017, and my opinion at that time was I didn't believe that there's like a hardship because of that subsurface condition. I continue to have the same opinion, and I'll explain why. Before the last hearing, we had discussions about every single cost item, foundation-wise, or the foundation items. We looked at the cost, and we kind of agreed on all the cost items except of two items, the underpinning and the excavation support. And that's why we asked the applicant to submit to us the drawings for the underpinning and the excavation support, which we got actually early in March.
You got what?
We got them early in March. March 8, I guess. Yeah, they were submitted to us. So I did look at the underpinning drawings and the cost estimate associated with that. And as requested by us, the cost estimate was very detailed. It did explain how the quantities were reached, and here are my comments on that. The first comment is that underpinning pier excavation and the approach pits. When we do underpinning, we come next to the building and we excavate a piece of land like 4 feet by 3 feet, and then we keep going down. They call this an approach pit. And when they start like reaching the foundation level, the bottom of the footing for the building that to be underpinned, they start digging underneath the footing for a very limited width, which according to the drawings, this pier length is 3 feet. And they go inside perpendicular to the building depending on how wide is the footing or minimum that's specified by the structure engineer. So the excavation for the approach pit should be part of the excavation for the building itself. So it shouldn't be considered in the underpinning cost. So this is the first item that I saw that the cost estimator consider that in the building excavation and again in the underpinning excavation. So this is number one.
Just so I understand, so it's been counted in excavation and underpinning?
Yes,
So
it's, when you look at the mass excavation for the building, and I'll come to that at the end.
I just wanted to clarify.
Yeah, you will see that the mass excavation for the building is taken from lot line to lot line in both directions. And then you factor in the height of the excavation. This is the way it's calculated. When you look at the underpinning, what they call them the approach pits are 4 feet wide, and they are all around next to the buildings that's going to be underpinned. And this kind of excavation is again counted in the underpinning and in the mass excavation of the building. So this is number one. Number two, the excavation for the underpinning and the approach pit was considered to be fully in rock, which is inaccurate. Looking at the geotechnical report, 2 borings were done, one in the front, close to, I believe it was on the sidewalk of 19th Street, and the second one in the middle of the lot. If you look at the 2 borings, one of them says that at the lot line, the depth to rock is about 9.5 feet. The second one, it says that the depth of the rock is about 11 feet. If we extrapolate between these 2 borings, we're gonna see that the depth of rock vary between about 9.5 feet to about 13 feet at the back of the rear of the property. Meaning that the average depth of rock is about 10 feet. The adjacent building footing, the footing of the building to be underpinned is about 8 feet below the sidewalk. So if you go to 8 feet and start digging, you still have 2 feet to reach the average top of the rock, and then the rest of the underpinning pier is in rock, and it is in decomposed rock. So not the entire excavation for the approach pit, nor the underpinning pier is entirely in rock. It's partially in soil and then in rock. So this is the second inaccuracy in what was submitted to us. The third thing is the width of the underpinning pier itself is 2 feet, according to the structural drawings sent by the structural engineer. The width considered for the underpinning pier in the cost estimate is not 2 feet, it's 3 feet. That led to 33% reduction in the excavation for the underpinning pier, in the concrete amount for the underpinning pier and in the square footage of the steel shims that need to be inserted after the underpinning is done. So this is by itself 1/3 reduction in these three items.
Okay.
The pricing used for the underpinning items, what I did for that cost estimate is I just recalculated the quantities and I factored in the prices. So I didn't touch some of the items. The quantity was incorrect, so I fixed that. Some other items, and that was actually the majority of the items, I believe the prices are really high. Like for example, one of the items stays steel shims between the underpinning and the existing building footing. This steel shim is just a piece of steel which is 1 inch thick by 2 inch wide, 12 inch long. So it's like a bar of steel. It serves 2 feet by the width of the underpinning, which is 2 feet. And instead of counting this by each and give it a unit price of, let's say, $50 each or so, what was considered in the pricing was counting this square footage. And the unit price for the square foot was $100. So if you look at the square footage served by just one piece, it's 2 feet by 2 feet. So this piece is considered at $100 each. I'm not sure if it's silver or if it's steel. So it's nice. Kind of
nice detail.
Yeah. So and if you look at the other cost items in the underpinning, they are all like that. So the underpinning cost, I believe it was greatly exaggerated. And then the big surprise for me actually was that what we agreed on before, I thought it's done, it's closed. I found out that the rock excavation amount for the mass excavation for the building itself, during the submissions from May until February, it was same number, about 100 cubic yards for the rock excavation. Only in this March submission, that 100 number was changed to 271, 270% increase without explanation. Again, the line drilling is when you excavate next to a building and you don't want to hit the rock hard, so you drill next to that building to create like a separation between the building and the rock mass. We call this line drilling. This line drilling was 306 square feet for the entire building. I did check this number in May and going through the submissions until February. And I did run the numbers for this number, and it seems like it's very legit. 306 is very reasonable number.
306 what, linear feet?
Square foot. You get the square footage simply by adding that perimeter where you're gonna do the line drilling times the height of the rock that you're gonna drill through. So that's how you calculate it. This number jumped from 306 to almost 1,900 square feet, more than 600% increase. Again, why? I have no idea. And for me, it seems like what we did before was like offset with this change in the quantities. What we did before is if you recall, we discussed the excavation support in addition to the...
Go ahead.
In addition to the concrete footings. Remember that discussion early in October about whether it's mat foundation or it's spread footings. And the board's opinion from the beginning was no, mat foundation is not needed, it could be a spread footing. All of a sudden, when they submitted to us the drawings for the underpinning, in the background, I have seen the foundation plan, and the foundation plan indicates that the foundation system is not a mat foundation. It's spread footings. And when we took the quantity for the concrete from 172 to 110, that gave us a reduction of 75,000, plus when they eliminated the excavation support because it's not needed per the structural drawings, that gave us a reduction of 200 grand. 200 plus the 75, so we reduced the cost for the foundation by about 275,000. And all of a sudden, in this submission, the rock excavation and the line drilling jumped up by 260. So for me, I look at this like it's okay, they took off some money, let's put them back, which is really make me, during like reviewing something like that, very cautious and nervous. So I did fix the quantity for the concrete, for the excavation, for the line drilling. One more thing, the line drilling for the underpinning. By definition, when you underpin building, you go underneath the footing of that existing building and you remove the material that you believe it's weak and it cannot support the existing building. This is the philosophy behind the underpinning. Now, looking at the quantities submitted by the cost estimator, he's claiming that he's removing 4 feet of material. Why? By definition, because they are very weak. But he's using line drilling to drill through that. Why? Because they are very strong. It's very hard to remove this. Two opposite things. The underpinning remove the overburden, which could be sand, could be silt, could be clay, and the decomposed rock. Decomposed rock is highly fractured, highly weathered rock. It doesn't need to be line drilled. I'm not sure why they are considering line drilling for the underpinning. Now, the final point, and this is for me, this is a bombshell action. That was like a big surprise. Looking at the geotechnical report, the geotechnical engineer did ask for test pits, dig test pits next to the existing building to make sure that the existing building footings are bearing on soil and the underpinning is needed. He wrote it in the geotechnical report. He said that if the existing building footings are bearing on rock, no underpinning is needed. Now, I'm looking at this like that. Do we need underpinning? I don't know. Because no test pit was done. So are we, even if we found that cost estimate legit and we want to proceed granting this, should we grant something based on an assumption? I don't think we should do that. So if they want to do test pits and they want to come back, it's up to them. But I believe currently I'm at the position that this project doesn't have any subsurface condition imposed hardship.
Right. And underpinning is done all the time. I mean, that's life in the big city, right? We underpin projects, and either you're finding rock or you're not finding rock. It has to be a unique physical condition, not just a cost, right? In order for us to have the A finding. And what you're describing is nothing unusual about the site. It's got to, so first we're at the A, not even whether it's supporting the B, right?
Yeah.
So the A is telling us, based on what you said, that there's no A.
Their main argument was that the condition, the rock condition that they encountered at that specific site is a unique.
Right.
My opinion is no, it's not. They are claiming that a typical site in Manhattan should be a sandy formation or a sandy silty formation to, let's say, 20 feet. This is incorrect. Rock is all around Manhattan. Some sites in Manhattan, you just scratch the ground and you see rock outcrop. So it's not a uniqueness. And even if you consider this, like if you look at it, forget about that word uniqueness now. Let's take a look at the coast. What is typical versus what is actual. Even if you look at it that way, the A finding is not there. And like I said, everything, right now the underpinning for the actual conditions was claimed to be over 600,000. When I looked at the quantities and I corrected the numbers, that did drop by about 300 grand. If, let's say it's 600, just for the argument's sake, let's say it's 600. Now, are you gonna add to the cost of that project $600,000 based on an assumption that just because the structural engineer and the cost estimator assumed that this adjacent building footing bears on soil, not rock, would you add 600 grand to the cost of that? I wouldn't do it. It's not an easy decision to do. And like I said, add to this, every single item you look at in the underpinning, you see like they are pushing the cost up. That for the typical condition, the underpinning pier is 6 foot high. And for the claimed rock condition, the underpinning pier is just 4 feet high. They tied this tiny 4 feet piece into rock with rock anchors, piece of rebar that you need to drill, epoxy, put some sort of adhesive in it, put a piece of rebar, 2 pieces, to tie this underpinning pier with the ground, and they did the same thing with the building footing. If you look at this tiny 4 feet pier, it doesn't have too much lateral force on it. If you look at that 6 foot high, the one that's 6 feet high for the soil condition, that's subject to huge lateral force. It doesn't have that. So how come you tell me as a structural engineer that for the soil condition, where the force is higher, you don't need to tie that 6 feet thing in the ground? Why do you need to do that with the rock condition, which is rock is much more stronger than soil, and it doesn't need that? So looking at things like these, you get the impression that they're trying to add every single piece of cost to that cost estimate to just exaggerate the cost.
Okay. So
Like I said, my opinion is no. It's
Okay.
They don't have a hardship because of the actual subsurface conditions.
Well, okay. It is a shallow, I mean, they may
No,
not
no, no,
have-
we're just talking about the height.
Just talking about the height.
There's 2 waivers. One is the rear yard
let me
and one's
just-
the height.
Okay.
Mention one more thing. I did mention that the rock depth is vary between about 9 feet in the front, close to the border on 19th Street, and in the back it's about 13 feet. I'm gonna do very simple math now. So 9 plus 13, that's 22. Divided by 2, that's 11. They are excavating to 13 feet. So imagine that this is the top of the rock, and we're going just average, 2 feet below that. To get the line drilling quantity, just add the 2 sides, 75 feet plus 75, because the line drilling shouldn't go all the way to the back of the property. So 75 plus 75,
Right.
that's 150 foot. Times 2 feet average, this is 300 square foot. That's what was in the cost estimate since May, 306. It didn't change this submission to 1900 almost. Why?
Right. Got it. Okay. So
So I would say, that being said, the biggest implication is for the A finding, right? So I would say that they have to rewrite their papers to only focus on the A finding being the narrowness of the lot and the taper, the narrowness, the taper, and the shallow depth. And all those costs that were premium special costs have to be pulled out of the equation. So if it is only $400,000, then it does not reverse the bottom line of the different scenarios. So what it does is it would still show that the as of right is not feasible, but it will, and by that it would come very close to netting out. However, who is going to invest in a project when all you could get is exactly what you put in? So that to me means it would not be feasible. The proposed, given a reduced construction cost, could be an overshooting of the E finding. So I would say when the final numbers are in, I would be better able to determine that. But based on about $400,000 coming off. I think the return jumps up to 8.5% annually and like 15% overall for the life of the project. And we have seen that before, and we have seen greater than that before as meeting the minimum. So, you know, I'm not quite sure that that's going to affect it, but to me, the biggest effect is on A, and what kind of resolution do we accept as a way to bring this property up to the situations of all the surrounding properties, so it is actually at an equivalent standing as they are, as opposed to getting an advantage over them.
Because my inclination, though, is because we always look at a variance as the thing that reduces the burden caused by the unique physical condition. So the most obvious one is when you have a shallow lot, a rear yard waiver is the thing that reduces the burden. When you have, to take an extreme, you're sitting on top of a subway tunnel and there's no way for you to excavate it all, and you must go up in order to provide everything, then the obvious waiver can be floor area, because you can't put anything in the cellar, there's no cellar, and height, right? In this case, we don't have anything subterranean, so I don't see any reason for a waiver for height. And we have seen the project viably as having adequate floor-to-floor height as a complying, sliver law compliant building. So I would say, having made no A finding as to subterranean, they should bring the height of the building down to comply with the sliver law, and then we just have the rear yard, and we can close it out at that. But I just don't think that we can keep going on and on with this one, especially now that, you know, all the material is in. There isn't any more proof to be made, right? And they had their chance, as Commissioner Sheta said, since October. He's been looking at the structural information, and there were a lot of times when we asked for the materials, we didn't get them. And so finally now with the materials, I think we have enough to make a decision on this. So if the applicant wants to move this along, they'll make a quick modification to the project and resubmit. Okay. Thank you. I know that was a lot of calculating.
Item number 19, 2016-4218BZ, 6679th Street, Brooklyn.
Okay. We had a threshold question with this 622. The diagrams and the axonometric still show more of the second floor perimeter walls being removed than not being removed. The perimeter walls have to be left on the perimeter and not melded into closets, et cetera, on the interiors. They have to be on the exterior of the building. We discussed this at the last hearing. We have a sample demolition plan now. Have you gotten that? So we have a sample demolition plan now that they should use, because makes it clear about what materials are actually remaining and what's being removed. We also talked about the needlessly tall attic area, which is not proposed to be used as occupiable space, and which is shown extending into the required rear yard. Most of the front and rear of the attic is shown as unusable. It's actually unstandable. Some of it's under 5 feet. So the building height should be brought down, consistent with the claim that there is only 433 square feet in the attic, because right now it's shown as this, basically the full roof. So these comments are actually a repeat of the last hearing, so I actually don't think the applicant was responsive, even though they made a submission. I just don't think we got anywhere with that. Anybody else on this? No? Okay.
Item number 20, 2016-4295BZ, 1074 East 24th Street, Brooklyn.
East 24th. Sorry, something happened. What happened to 2017-204?
Let's put next.
Uh-oh. Where's East 24th?
Number 20?
That's what I just did, number 20. Uh-oh.
No, that was 6679.
6679 Street.
Oh,
Did you just read the wrong?
I just
comment?
read 24th Street. Uh-oh.
Okay,
Sorry.
let's go
All
back.
right, so we're going to go back to
That
item
was
number
mine.
19,
I'm so
2016,
sorry.
4218BZ.
Nobody would, no wonder no one said anything. They were like, huh?
6679th Street, Brooklyn.
We thought we read the
Sorry,
number.
and now I have, what?
Oh, no, never mind.
Okay, hold on, let me just, so 20, yeah, I was looking at that, but it kind of looked like the one that I was talking about, so, all right, so we're doing number 19, 2016-4218BZ,
Yes.
correct?
6679th Street, Brooklyn.
Okay, apologies to the recording, which will be confusing. Okay. Changes were made to the plans to ensure retention of 50% of the exterior walls and joists. Why didn't you say anything?
Yes.
I thought I reviewed it incorrectly, since I did one such, so I kind of,
Oh,
I need to go
no.
back and re-review my notes.
The actual opposite of everything that was just stated.
Exactly, so don't get nervous, whoever was listening, this is a different one, okay. That required eliminating the front balcony, that's how that was accomplished, which created the opportunity for a pitched roof that slopes to the so-called attic floor, which really isn't an attic, it's really a third floor, but I think I like how the pitch works, because it creates one of those little clear story windows that are so typical of attic floors. However, the building is still 10 feet higher than the neighbors, although that 12-foot setback with that pitch from the front wall line helps. I'm still not sure how you justify this huge height, because it's so much higher than the neighbors, and that third floor is not being treated like an attic at all. It has full head clearance throughout, and the floor to peak is 13 feet, and the interior ceiling height is 9'6", so there is room to bring it down. So I'm like, I understand, I really do appreciate that design effort that was made at the front, and I'm wondering whether there's a way of accomplishing something similar around the sides that makes it read more like an attic, and then you bring down the height to something that's more attic-like, and then even though it's still tall for the neighborhood, it's more typical of an attic reading as opposed to a third story. Oddly, though, despite all of these changes, the floor area keeps creeping up. Now it's at .91. I think it started at .84.
It's at .87, right?
No, I got .91 on the last submission. It was .87 at the last one, and it was .84 at the one before.
Okay, so then maybe the zoning analysis is not corresponding with the revised plan.
I'm just opening up the file. There had been an issue with the statement of facts not having the correct floor area, and it had the applicant revise it, so.
Okay, but so this
There had been
isn't
at
the
one-
statement of facts, this is me just reading the drawings.
Okay, yeah.
Okay,
So
so
the
the drawings are showing .91. Maybe we had some problems with prior submissions about what was the right floor area, but I had, the original submission was .85, then the next one for January is .87. So there's been floor area creep. That might have to do with the fact that they eliminated that front porch to retain that front wall. But so the FAR study, though, I think is better this time, but last time it wasn't very supportive of that 0.9 FAR. The study now identifies 6 houses around the corner in the R2 with FARs in the range, but none of the actual social block are in the range. We always talk about how you can't see FAR.
So you have .91, right?
.91.
Yeah, so that's what all the most recent materials all say .91. Yeah, there had been a discrepancy in their original submission, and I had to quickly just correct it. So the analysis sheet and statement of facts should all have point.
Yeah, the drawing shows 4178 square feet, which is .19, and the last zoning analysis sheet, I was looking at the previous zoning analysis sheet, that also shows .91 FAR. So
Okay.
those two are consistent. I don't remember the statement of facts.
Okay.
Yeah, I didn't even,
Okay.
when we get these submissions, I tend to just look at the drawings, what did they change, and try to figure it out. Most of the time, they don't tell you. Okay.
Okay.
All right. So I'm just still on the, how do you reduce that apparent, it's a lot taller than the neighbors. And, you know, they've never, and I think the perspectives are very helpful and so on, but they don't give us anything about the heights of the other buildings on the block. They don't tell us that, oh, look, there are other buildings that are just as tall as this one on the block.
They had submitted, in the FAR analysis, there were some photos of the buildings.
But those aren't heights, those are photos. And so we don't know, they're photos, they don't provide us with height information about the block. This is an area where a lot of the houses are built on these platforms,
The way I
right?
was looking at this particular building and comparing it to all the other built context here is that, as you said, most of them are built on a platform. So that all of them consistently are at a grade higher than the street level, the curb level.
Right.
Second of all the ones, all these buildings, they go pretty much straight up. This building at least has made the attempt of setting back quite a bit from the front street wall line to allow for the third floor to go up. So, for example, all these examples of the buildings that they have shown, it's like a 3-story building that's almost going up straight up, whereas here the third floor is set back. And I think from the renderings that they have shown, it does show that the building is not going to be as imposing as these other 3-story buildings where they are straight without any setback. So I'm actually okay with this correction because it does reduce. From the previous one, it was the first story, and then I think it was a 2-story.
It was a setback.
It was a setback,
porch.
right. It went up to second floor and then it's set back, and now it's setting back after the first floor, it's setting back, right?
No. It takes advantage of what had been
Right.
porch. It
Right.
uses that as a
Right.
way to create, it stays out front.
Yeah.
But it uses the roof of that second floor as a way of making the transition
Exactly.
instead of having having a porch,
And it's
right?
almost like if they had continued that second-story roof line, and it kind of continues, that you could have had
It does. So that little
and-
porch there is actually cut out.
Right.
So you
So
see the roof actually
One could have a
continuing.
second story with like an attic almost, and this, so I'm actually.
You're okay with the
I'm okay
height?
with the solution. And, you know, we see so many projects where they encroach into the rear. This is staying
Yeah.
very much well within the 30, well
far
far
beyond,
beyond.
yeah.
So they really are trying to keep the area as contained as possible, trying to be consistent with what is built. And there are buildings there where it does go straight 3 stories, and here
This is at least
It is
not
setting
doing-
back, so
This
I-
actually has 2 steps to it. It has the first
Right.
floor, and then
Right.
there's a step,
It is-
so
it
it
is set
actually
back
steps several
even,
times.
right, it
more
sets
than-
back
yeah.
quite a bit, even from the existing property line. So I think this is a reasonable solution.
Okay. All right then. Okay.
Okay, item number 20, 2016-4295 BZ, 1074 East 24th Street, Brooklyn.
So that's the one I read. Do I read it again?
Can you read it again?
Okay.
Yeah.
Okay. So this one is about the threshold question, where we have diagrams and an axonometric that still show more of the second floor perimeter wall being removed than not being removed. The perimeter wall has to be left on the perimeter, not melded into closets, et cetera, on the interior. So the perimeter has to be on the perimeter, that's called the exterior of the building. We discussed this at the last hearing, and we've been discussing this pretty consistently with these 73-622s for months. They need to provide an actual demolition plan using the model that we have for them that we can send to them. We also talked about the needlessly tall attic area. Maybe that's why you thought I was still talking about the other application. Needlessly tall attic area, but this one has a very odd attic, which is not occupiable space. There's only a little area in the center, and then there's like this double height bedroom, and you crawl on top of the bedroom, and then there's some other kind of strange thing going on where you crawl on top of that. And so it seems to have no purpose except for maybe future use, kind of. So that is extending, that unoccupiable space at both the front and the rear are extending into the rear yard and into the front yard and don't serve any purpose. So, so the building height needs to be brought down to be consistent with the claim that there's only 433 square feet actually in the attic. And again, all of these comments were from the last hearing, so I'm not really sure what it was that they said they were affixing to be responsive to our last comments.
Yes, I remain concerned about the roof within a roof, as I call it. I'm not sure why that is being hidden in the attic. If you want the master bedroom, and that's an architectural, that can be very easily been folded into an architectural interpretation and allows for the building and the use within it to have that double height room and can be expressed from an exterior point of view without having to change anything with the space need. So therefore, I'm not sure why there is so much resistance in doing that, and that would reduce the height in the front a little bit and bring it more in the context. It's something that I think I'd raised in the initial hearing also.
And also it reduced the height in the back because there's that other, it's not even really a roof within a roof. Well, on the front, it's the ceiling of the master bedroom, and in the back, it's this big lump in the floor. I just don't even know what it is. So, just, okay.
Item number 20.
Yeah.
Item number 21, 2017-204 BC, 124-14-27 Queen.
Okay, the applicant submitted as requested an area study to establish the subject site's uniqueness. As it turns out, there are actually 7 other commercial corner-like lots in this R district within 1,000 feet of the site. I was actually surprised to see there were so many commercial uses in the area. 3 of these are on much larger lots, and 3 of the smaller lots appear to be mixed use, so with conforming uses with retail ground floors. So those are all distinguished from this site. And 1 of the sites appears to be fully residential, so that leaves perhaps 1 other site as burdened as this one, so that's pretty unique. Financials were revised as requested.
I have no other comments on the financials. They were revised. They were responsive.
Okay. Anybody else on this one? Okay.
Item number 21. Item number 22, 2017-240 BC, 310 Lenox Avenue, Manhattan.
Okay. This is really a fire department issue that the fire department, I know, submitted some materials, and I just would like Deputy Chief Daly to speak about this application tomorrow. Fire department apparently inspected for a public assembly permit compliance and had asked for some changes made to the interior spaces to make it safer. I just wanted to know pretty specifically whether, or actually specifically, whether fire department is okay with the proposed egress conditions, the cellar waiting area for more than 75 persons. There's this one kind of room where they're supposed to wait, I guess, before the set starts, where there's egress from the prior set and the next set starts, where there's more than 75 people who stand in this room. And to understand, and to make sure the fire department understands the issue about simultaneous occupancy with the operation of the event space and the office space that's above, where the issue is lining up for events in the lobby, the office building lobby, and egress from the upstairs offices. It's just kind of, it's 2 uses combined that are not typical, and so I just want fire department to be aware of that and make sure they're okay. And just to, as a reminder to us that the term limit for the special permit is 3 years. Anybody else?
Just know for the record, the applicant did make a submission
this morning.
This morning? Oh,
This morning in response to the fire department's letter?
okay.
Okay.
Also, just in terms of the term, this is legalization, and so for PCEs, we typically tie the term to the date they started operating. So
Right.
for your consideration, whether the 3-year term will start as of the day of vote approval, or whether it will date back to the actual start of operation. I don't know if that's within the 3 years. I don't know.
Yeah,
Probably
I
is more
have
than
to.
3
It's
years.
been operating like this for a long time.
Okay, so
I
then
need
it
to
sounds like
find
it
the
would be
date.
from the date of approval.
Yeah.
Okay.
Right.
Right, I did look at the submission this morning.
Oh, you did?
You're right, and the applicant is accepting all the conditions that FDNY has recommended, and that they will implement those.
I thought that they were actually in response to the removal of all the obstructions in the corridor, stating that they wanted to keep them but have them be fire rated and subject to DOB approval. Number 5.
I think one,
The applicant shall be permitted to install storage cabinets within this exit passageway, providing such cabinets are fire rated and accepted by DOB.
right.
Whoa.
So, yeah, so they did respond that they wanted to do something other than what?
So I think the safest thing to do is to just have Deputy Chief Daley review the submission, and if necessary, speak to others at fire department, however that works, and see whether those changes are okay. And then the other question is whether the changes should be made now, prior to grant, or whether fire department feels like they have enough, let's say, knuckle sort of power to take care of this on their own, or whether it should be tied to prior to the grant, or to prior to the vote, right? That's a question. I'm not aware of allowing to have storage cabinets in egress routes.
I mean, unless the fire department said they could do it, maybe the fire
Well, fire
department said
department
do
has
it.
to
Yeah,
opine, right?
yeah.
Then you reduce the amount.
I always thought you're not allowed to have storage in a route of egress unless it's a very wide egress route, for a lot of good reasons. Okay. Anyhow, okay.
New cases, item number 1, 2017-8 BZ 356-362 East 139th Street, the Bronx. This is the Academic Leadership Charter School.
Correct. We have proof of service of initial application to officials and of notice of hearing to officials and neighbors. Community Board 1 recommends approval. So I have a bunch of questions. With respect to the projected enrollment, the statement of fact states that at present, the breakdown is 304 elementary students and 250 middle school students, but the proposed is 275 elementary and 325 middle. So I'm trying to understand, why is the elementary school figure going down on the proposed school? I know that there's still another school that will continue to operate. I'm also, but in that same sense, I'm not really understanding why the 2022 expansion plans are not incorporating all of the elementary school children, and why 304 of them will be left in what's described as inadequate facilities on 141st Street, which is PS 65. More on that general subject in a minute. I'm wondering also why, because I never really understand this about the breakdown of classrooms, why there are 2 classrooms for grades K, 2nd to 4th, 3 classrooms for 1st, 6th to 8th, and 4 classrooms for the 5th grade. Like, what happens? The kids get kicked out of school, and then we take new kids in? I mean, I'm trying to, normally we see it start small, and then more kids come to the school, so they'll maybe add a classroom. And then at a certain grade, like 5th grade, the place gets really popular, and all the kids want to transfer from wherever else they are. And so the 5th grade explodes, and 6th grade is the same as the 5th grade, and on till they graduate, and maybe the school's lucky and they open a high school. That's what we normally see. So this is kind of an erratic classroom.
I had the same
Yeah.
question, because it starts big and then gets smaller and then gets big again, and then So it's
Right.
very strange, but I just was wondering if it had something to do with the other site. Maybe the layout in the other site allows them to have more second, third, and fourth graders, so they don't need them here. That's what I was
Right.
wondering, but I had
Yeah.
that same question.
Yeah, because it seems like if the whole goal is to get the school to be this cohesive unit where they have this great teaching program, and they have all these good facilities, you want all the kids to be together, and you want the classes to travel together, so that was confusing. There's no discussion in the statement of facts for the need for 28 parking spaces, and that's where I'm going about why don't you want all the kids to be in your school. The programmatic needs report describes it as a convenience. The transportation study shows approximately 15 auto trips for staff, some of which may be drop-offs. The site is very well served by public transit, and there's no discussion about other school sites having parking. Parking is rarely, if ever, included in the schools that come to us for waivers. I actually can't think of any. Eliminating parking would allow the gym to be dropped into the cellar level and reduce the need for height waivers, not to mention the loss of space for the ramp that goes into the cellar on the first floor, and the option to locate mechanical and storage space, which is now on upper floors, in the cellar. Eliminating parking might also allow the balance of the school, those 300 kids that are still in that under, let's say, substandard public school, to relocate to the new building, which is a stated objective in the programmatic needs report. So I really don't understand this. And yeah, there's also a version of this project in the programmatic space analysis report that shows, so there were lots of different versions of the school and all the different documents provided to us, that shows a subcellar and a cellar for parking of 31 spaces. So that sort of tells me, oh, wow, so there's a possibility to go deeper. That even is a possibility of having the gym deeper still and more facilities that can go in a cellar. And now you get all the classrooms and maybe like some administrative offices and things like that that don't really need to be above grade. And then you get all the kids in the building. Wouldn't that be great? So the diagrams that were provided in that report appear to be more developed, actually, than the proposed plans, with significantly different layouts at all floors. So I'd like them to explain that. And when I say more developed, those look like the ones that the architect started to pursue, really, like laying out the desks, figuring out the specifics of door swings, all of that, as opposed to what we have now in the proposal, which is a very schematic set that doesn't look like it's been as carefully worked out. Then other question is, I'd like to know what the material of the fence enclosure is around the outdoor areas, because that's always something that makes a building look much taller if it's opaque. And recently on schools, we've seen that expanded wire, which is a more translucent looking material because you don't see it, it's not as opaque generally looking. We need east and west elevations showing the finished materials. They should show a map, provide a map showing the other schools that are referred to in the statement of facts as being close to the subject site. They should provide heights as opposed to floor numbers of the 7 to 8 story buildings that are located 2 to 3 blocks away from the site as a way of supporting their own height. Just as a note, DOT School Safety expressed that they had no issues. The DEP letter on February 14th had questions about the noise studies with respect to the outdoor spaces, in particular about the 3rd floor setback, which is going to be basically where the kids go during lunch, so I'm imagining that's really noisy. DEP requested changes on February 16th to the Phase 2 work plan and HASP. And I note that although the EAS states that area noise levels do not exceed seeker thresholds, they were estimated to reach 66.4 decibels, so window wall assemblies should take this into account to ensure that interior noise levels caused by outside noise sources do not increase beyond 45 dBA. So that should be a notation on the drawings. With respect to the shadow study, I'm confused about the shadow study. The conclusion makes it sound like those were incremental shadows, but the drawings don't show any buildings in the way of the school. So, for instance, there's a study on December 21st that appears that has this building casting shadows for more than 4 hours on the Willis Playground, but the modeling doesn't look like it takes into account the buildings that are adjacent to the playground that also cast shadows. So it could be that the incremental shadow isn't 4 hours plus on the entire playground, but an extra hour at the end of the playground at the end of the day. So I really need that clarified. Okay. Anybody else?
I think my biggest question was the parking space. We have seen so many, as you have said, we have seen so many projects where parking with school has never been asked for. The documentations is not clear as to the need for it. And can that be eliminated? And if not, what is driving it? That to me is the driving question, and with that, that would answer some of the locations of the uses and the height and setback of the waivers. In terms of the neighborhood context, it's a very dense neighborhood. It has a lot of tall buildings. I think that's not that much of an issue, but still, we need to understand the need for the program and how that is driving the height.
I also had that other question that you had about the relationship between the plans that are in the spatial needs report to what's actually being proposed. And I wanted some information about the operational plan for the arrival and departure of students via bus and also walking or drop-off. And I wanted to say that the outdoor play areas should not have any lighting or amplification of sound.
Good point. Yeah, it's been a while since we've confronted a school that's actually using their roof, right? Okay. Anybody else?
No, just quickly, the aerial photo that was submitted showing the number of stories for buildings around, if they can provide us with a height study, like with
actual feet.
Yeah, exactly, yes. This is one thing, and I was thinking about the possibility of like lowering the, eliminating the parking and putting the gym into underground so they can save something on the height, because I believe this building will be kind of one of the tallest building in the neighborhood. So if they can do that, that could be helpful for reducing the height waiver.
Anybody else? No? Okay.
Item number 2, 2017-191BZ, 47 Green Street, Manhattan.
Okay, we have proof of service of the initial application to officials and proof of hearing to officials and neighbors. Community Board recommended approval with modifications. It says they recommend approval on condition that the BSA apply its expertise to determine whether findings are actually met, that it stipulates no eating and drinking establishments, and which is common in this district, and that it encourages the applicant to find tenants whose business is appropriate to membership in the Soho Design District organization. Okay. But yeah, all within our department, but it's true that this particular community board doesn't like eating and drinking establishments in Soho.
Many of them.
I need to make special note also of a comment in Community Board 2's letter about why this applicant brought this action to the BSA. The pre-applications are which basically said that the BSA recommended that the applicant come to the BSA, and based on a pre-application meeting. So I just want to say that pre-application meetings are conducted by BSA staff as a courtesy to the potential applicant and at the request of the applicant. The pre-application meeting is not the review of the application by staff prior to calendaring, nor is it the review by the 5 commissioners prior to and during the public hearing process. Applicants must make their own business decisions about whether to file an application. I find it absolutely intolerable that an applicant raises the subject of a pre-application meeting to defend its behavior, either before an official body, the public in general, or during the hearing process. We have stated this to this applicant before and will not do so again. I can't express this more strongly. The truthful answer to CB2's question about why the applicant didn't go to city planning to request a special permit to allow this use is that in the applicant's view, the special permit 74-781 process at city planning, which requires a year of good faith marketing effort of the space, just takes too long. And that among other things, because it's also a broader public process, it goes to the borough president and city council and so on, but it's not subject to seeker, notably. And that they preferred the BSA variance route as a shorter process. That's the actual answer to this, and I think it's important for the commissioners to understand that there is an alternate route to solving this use at city planning. And when I practiced before all of these agencies, I did many of these applications, and they were actually quite easy to do. You start the advertising process while you're filling out your paperwork to submit to city planning to get the special permit, and by the time you've had your meetings with city planning and they've worked out the details and all of that, the year is up. You've finished your advertising, and for the most part, there aren't any takers, because the fact is the rents, even at the so-called market rent for the conforming use, are just really, really high. And so there are no takers. So, yeah. So, having said all that, we have 3 letters in support from different addresses, but all from the same person. So I'm kind of assuming that that person is related to the owner of this building. Even though I can't prove it, it just seems logical. Uniqueness that is claimed is that the building can't be used for manufacturing, but there are many non-manufacturing uses permitted in the district, including wholesale sales. Wholesalers have similar delivery needs as retailers, so I don't see the issue with the loading dock. Practically no buildings in the Soho Cast Iron Historic District have loading docks. Back in the day, trucks offloaded from their elevated rear lift or drop gate via temporary ramps that led directly into the elevated workshop storage floor. So literally, and later, as they got more sophisticated, they put these cool little rollers on them. So the box just slid along on rollers right into the space. So pretty efficient. The board has in fact rejected the absence of a loading dock as a hardship condition in other cases, one of which was supplied to us. Thank you very much. Further, unlike many applications of this type, there is both a passenger elevator and a service elevator with direct street access. So many of the cases that the board approves only has a passenger elevator. And so, yeah, it's true, without a freight elevator, it can be tough, right? But here they have both. So you don't even have a conflict between residents and commercial use, which is sometimes another reason why it's a, let's say, understandable issue. I'm also confused about the claim that the doors on the building are only, quote, pedestrian widths. A person door is 3 feet wide. The space between the columns is over 6 feet wide, although actually the dimensions were never provided on any of the drawings that were submitted. And so I'd like to know, since when is a delivery access for rolling hand trucks and pallets greater than 6 feet needed? Pallets are, by the way, 48 inches by 40 inches. So that's 4 feet by 3'6", or 30 by 40 inches, or 48 by 48, and are often unwrapped on at the sidewalk. We often see that, where they deliver the pallet to the sidewalk, and then the boxes are taken apart, and then they slide each box into the space. But you could actually fit a 48-inch pallet right in through that 6-foot wide door. with respect to the width of Green Street, that isn't particular to the zoning lot, but to the entire neighborhood. And again, I don't see how a wholesaler with similar delivery needs to a retail is disadvantaged by it. So I'm not persuaded that the site is unique, and none of the cited cases support this finding. With respect to the ability of the building to realize a reasonable return on investment, I'm most troubled by the building's continuing state as an interim multiple dwelling. And this is one of those interim multiple dwellings that existed since the creation of the loft law.
Yep.
Right?
Yep.
It's like, this is what it was for, Soho, not Bushwick, right? Soho. And so, and no information about that IMD was given, but of course, everything is online. So loft board notices and orders show that the owner has been out of compliance with loft board legalization and code compliance deadlines since at least 1992, and that's just because they kept extending the time to comply by the loft law kept getting amended.
Right.
So the landlord was out of compliance a lot longer than that. It just kept getting extended. Failure to make necessary improvements to the building has resulted in freezing the rents and in an inability to obtain a certificate of occupancy for a use group 2 use. Use group 2 use, residential, is extremely valuable, especially in Soho, and is not limited, and the use isn't limited to joint live work quarters for artists, where arguably you're supposed to provide from cultural affairs a certificate of being an artist, right? This is just, anyone can rent this. Anyone who can afford it can rent it. So I see this building as having created its own hardship. In addition, given the battles between the IMD tenants and the landlord that are in the public record, and vacancies of some units noted in the May 25th, 17 financials, it appears that the building is being vacated slowly and will have access to market rate rents or sales. I'd like to know also whether more units have vacated since May of last year. I note that there is a very lengthy and frankly strange email to the project manager. Oops. No, that's not it. Where is that? Sorry. That's a misplaced note to another one. So never mind, that was the end.
Yeah, got it.
Delete. Yeah, delete. Okay, that's my comments.
Well, I agree, like the chair, that it's very hard to find a uniqueness finding here. I think that just about everything that they've suggested are conditions that just about every single building in Soho has, at least to this extent and possibly even more. You didn't talk much about, I just want to add to it, the small floor plate that they're claiming that they have. They have a 48 by 100-foot lot, and many of the lots within this area are much smaller. As to them citing the different variance cases that have been approved by the BSA, just about all of the cases that are claiming that they have small, narrow lots are far smaller and narrower than the subject. And the few cases that actually we granted variances to larger lots than this, it was because there are other issues in addition to the ones that this applicant is claiming, which led us to consider that perhaps they were, due for some kind of waiver in order to even the game for them. So I don't find this application convincing on the A finding at all. But should we get to B, I do have a couple of questions about B. One has to do with the comparables for the site value. Comparables number 3 and 5 don't really state what the use is in those buildings, and there is no C of O for those. So if they could just detail the use so we could determine their comparability. As to their retail leases, they're using 3 old leases from 2014 to 2015 for much smaller spaces, as well as an asking space lease for 1,500 square feet. This leads me to think that they might have undervalued the amount of rent that they could get, because all of the leases are for inferior space with very little frontage. Also, no storage seems to be provided for those spaces. And in the actual pro forma, the retail rent that they're assuming is only applied to the ground floor square footage of the subject building. And this could be a problem if the comparables and the rent that were set by the comparables don't include any cellar storage space, because this property has a very large cellar that's not just used for storage space, but it's also used as selling space. And so therefore, I'm worried that they might be leaving out income to an entire floor. And that would impact, the E finding.
Is that it?
Yes.
Yeah, okay. Anybody else? No?
Just one
Agree with
further
your
on
comments.
their economic analysis, what the Commissioner was saying is,
Could you speak up?
what
Sorry.
the Commissioner was saying with regard to the value and the project value as of right use now, I just don't see how that adds up at this point, if they can explain that a little further.
Could you be a little more specific?
On Exhibit 1, they try to explain their project value, their project cost and their project value. It seems like their project value at nearly $9,000 doesn't, I don't know how they arrived at that with the space that they have.
And that goes to the whether they have accounted for the cellar space or not.
Right.
That
Oh, you mean 9 million?
Yeah, but
Yeah.
9 million.
Nine,
sorry.
yeah. Okay, 9. Yeah. Okay.
I have similar concerns. Being raised.
I say 9,000. I said 9,000, yeah.
Yeah.
It's like, oh, but 9,000.
We knew what you were saying.
And so,
If you're not gonna pay him, you could say that.
Okay. Ready?
Yeah.
Item number 3, 2017-213 BC, 1808 Coney Island Avenue, Brooklyn. This is Dynamic Youth Community Center.
Right. Yeah. We have proof of initial application to officials and of notice of hearing to officials and neighbors. Community Board 12 recommends approval with 17 in favor, 6 against, 5 abstaining. We also have letters of support from State Senator Golden, Assemblymember Simbrowitz, Councilmember Deutsch. We also have 5 letters of support from social service organizations, and approximately 38 letters of support from neighbors and area businesses. There's also a letter from New York City's Department of Education's Alternative Schools and Programs District 79, and from New York City Department of Education's Restart Academy, both in support of the project. And on the other hand, we have approximately 50 letters of opposition, several from area private schools expressing concern about the residents of this program and the potential of endangering area children. The applicant should speak to those concerns. The name of the program seems to move interchangeably between dynamite youth and dynamic youth. And actually there's a sign on the building, I think that's the one upstate, which says it's dynamite youth. So I'm confused. So can they explain what that is? Or is that correct? Are there 2 programs? I just want to kind of make a note about how some of the things we learn about what the project managers deal with when we handle these applications. We read about those things because the exchange gets inserted into our materials. So we find out that there was this very lengthy, and I found actually strange, email to the project manager arguing that no programmatic needs analysis is needed for this application, where the applicant is claiming Cornell deference and is a nonprofit. So without a programmatic needs analysis, the board has nothing on which to hang any of the applicant's claims to the A deference or to the E minimum variance finding. The applicant is well advised to respond positively to the requests made by project managers. They are there to help and ensure the application is complete and ready to be heard, and often will speed up the application process if you're responsive actually to their requests. So, to that point, I'd like to understand more about embedded teachers and how the DYC dynamic or dynamite? Dynamic or
Let's call
dynamite?
it dynamic for the time being.
Okay, well, that's the thing, they keep dynamic youth and New York City school teachers work together, and also to understand who from dynamic youth at this location enrolls in the Restart Academy, and how such participation in that program works. Do teachers come to the facility? How many teachers are there? Which ones are full-time? How does the teaching program work? How many people are currently enrolled in the high school equivalency or GED program? What are the teaching hours and where does that occur? How many participants are high school graduates, and how many participate in vocational programs? They need to provide a schedule of classes and how the classrooms are used. Also, how are the residents involved in what they call community service, which is described somehow in the papers. Where and how do what are described as building trades education occur? Because really, can it be that all of the building trade training, such as tile laying and fixture replacement for 75 enrollees, occurs on site when they need to occasionally like retile the bathroom? So I had a lot of trouble with that particular statement. Of the 59 enrollees who are not in residence at the 1826 building, where do the majority go after treatment/counseling? Who is selected to be residents? And if the ideal is that all 75 of the second-year enrollees in the program are residents, how are a total of 36 beds adequate to meet programmatic needs? If the residential program upstate is the first step, how is it a transition towards independent living to move participants from upstate to another dormitory facility in Brooklyn? I thought you're supposed to be taught now how to live independently, so I don't really get why you live in a dormitory again.
Yeah, I
So
thought
Dynamite has a, from what I understand, Dynamite has a very particular type of, the first step is the getting off the substance that you're on, and then you transfer to the after you're no longer, after your withdrawal symptoms, and again, I'm paraphrasing, then the next step is for you to start learning, like get therapy and start learning how to become a member of society again in good standing. And while I didn't see it in the papers, I'm pretty sure it's only for a certain age group of people between 18 to 24.
Yeah. It is in the paper.
Okay.
That's in the paper.
That's one of the reasons that I'm asking. So they're saying, it's actually, I thought it was 16 to 20.
It might be 16 to
Yeah.
24.
So I understand the 16-year-olds are obviously missing out on finishing high school, and the 18-year-olds may not have finished high school, and certainly there are older kids who might not have finished high school. I understand why they would be in that Restart Academy program, but that's why I wanted to understand, what about the ones who are already have finished high school? If that's the case, then, because this is a Cornell deference argument, right? So we need the educational connection, hence a very strong tie to what the Department of Education is saying is their connection, that they send teachers there and so on. But if it's to teach 3 students as opposed to, the majority of the 75, the link is more tenuous, right?
Right.
Yeah.
Doesn't it also have to be in connection with this actual geographic
Yeah.
site? Because they have another site
Right.
on the block, and all of the paperwork or file information that's on the internet has to do with the other site.
Right.
That is already a part of the Restart Academy. But what does this site have to do with that?
Right.
Is there an integration of the educational program here at this site? Because there's only one classroom.
Right.
So you kind of wonder, like, what's really going to be going on here?
Right. Yeah, and that I think is part of the question is, has the board looked independently at a dormitory? Because that's effectively what this building is offices and dormitory space. So I'm not really getting that. If you want, because we have seen that kind of thing in other programs, like the physically frail, whatever it was called.
So, oh yeah, the medically frail.
Medically frail, right. Medically frail was a really excellent example of live-in teaching, where the students had to live in this building. It's impossible for them not to. And so the teachers either went to their rooms, because children are so disabled, the teachers actually went to their rooms for private tutoring, or the children were brought down into classrooms in the building and had classroom activity. And so the linkage, super tight, right? In this case, it's basically this dormitory / administrative building, and it's not clear at all how that's linked to an educational program. And so, you know, to make that clear, it seems to me you need to take out all the administrative offices, move them to the other location, and move all the classrooms to this location, but we don't know anything about what goes on in the other location. So we need drawings, like what's going on at that other site that you're claiming educational deference? And is it possible for us to make a physical link between a building that provides the educational services and this building that doesn't, and still use Cornell deference? I'm not sure about that. So, and also in response to the concerns of the community, the program describes 5 dorm rooms, but no room for a live-in counselor or manager. It says they have monitoring staff without a place to stay. So that sounds to me like a night watch person who, like, most of the time reads a book and isn't really, it's not the same thing as a counselor. So if you've got people who have serious issues, mental health issues, serious ones, right? So seriously, you're going to be monitoring them by having a person who's like maybe union, who checks in, checks out, and isn't part of the whole educational program, the program that is servicing the youth. And you would think that that person would have to have a place to live in the building, in-house counselor, right? So I found that particularly strange. I also, and as Commissioner Otley Brown mentioned, there's only 1 classroom at the 2nd floor, and the rest are offices. And then like to know how the as-of-right drawing is as of right, because not-for-profit with sleeping is not permitted in a C8 district. So that's actually a lesser variance. So I think that a real as-of-right drawing would be one that's showing more of the non-sleeping community facility use. And like, why can't that just be done, more of that be done in the other site or something? Like, why not an amendment to that other variance that was granted? And like switching out these 2 uses maybe. And then also the building, in particular, because this building is really tall for the neighborhood, granted that the zoning it's an allowable floor area, but it's super tall for the neighborhood. And since it's mostly an administrative building as opposed to a dormitory, again, you could say, why can't you bring down the height, take out the administrative functions, have a couple classrooms that service those many kids, and then it doesn't need to be as tall. I don't think programmatic needs has been justified, other than perhaps those dormitory rooms for something happening off-site. We also need side elevations and building facade materials on the sides. And Department of Environmental Protection had noise and air comments as of March 8th, but agreed on the E designation for hazmat.
Right.
And I just want to make one comment. I don't know if anybody's here from the community, but the community complaints were, we're a residential neighborhood, move this to a non-residential neighborhood. A C8 is a non-residential neighborhood. It's an automotive use neighborhood. There aren't any other places that you can go where you're away from residents except manufacturing and C8 districts. So, anything? No? Okay.
Item number 4, 2017-280BZ, 33 Bond Street, Brooklyn. This is a PCE, Chelsea Piers.
Okay, we have proof of service of initial application to officials and proof of notice of hearing to officials and neighbors. Community Board 2 waived their hearing of the application. We have Department of Investigation sign off. They need to incorporate their acoustical notes into the plans. There was acoustical notes on the statement of facts that aren't shown on the plans. And they need to tie the details that are shown on BSA 08 to 10 to the floor plans. There's all these individual details, but they don't key them into the floor plans. So you actually have no idea where any of those details occur. I'd like to know whether parking is being supplied to meet the zoning resolution requirements. And the operational plan that says no dropping of weights will be permitted should be incorporated into the conditions in the resolution and appear on the certificate of occupancy. So they said that they're going to tell all of their patrons not to drop the weights, so that should be someplace where everyone is on notice that there's no weight dropping. Okay. Anyone else?
So you want acoustical notes and plans,
Yes.
and on the B08,
So BSA 08, 09, and 10, they have our detail sheets of
Right.
acoustical details, which are floating there in space because unless they're
so
keyed
you
into
wanted
the
them noted on
plan,
the...
you don't.
So you want the detailed plans on the same plan as the...
No, the detailed drawings are included in the set. We've
Right.
done this before.
That's right, I'm
The detailed
sorry,
drawings
yes.
are included in the set.
Yes, sorry.
They'll say detail number 5 of 08. So then you take a little circle and you put it on the drawing and it says, go to detail number 5 of 08 and now I know what to do on the ceiling, for example.
Okay, sorry.
So they need to reference the details on the plans.
Yeah, exactly. Okay.
Okay. This
Wow.
concludes the public review session for March 26, 2018. It's a good thing we don't have anybody behind us.
We'll make plans tomorrow night.